One detailed matter.
For hearing matter, for inclusion matter.
And application for restoration. Application for restoration.
Upgradation for restoration.
No.
Application for restoration. देखे नहीं होगा गोलमाल ना हो जाए.
This is for hearing, for inclusion. No, Lordship has allowed twice, but not coming in the list. That's
না আসলে কারণ হিয়ারিং ম্যাটার না আসার কি আছে?
great.
Under the compelling circumstances, your lordship may be allowed to mention one matter for inclusion and take the matter, your lordship, on next week, any day, your lordship, or Monday, your lordship. What is the urgency? Is that, your lordship? The urgency is that, your lordship, petitioners are the lordship, the resident of a colony, your lordship, a Biddasaur colony in Howrah. Now, your lordship, on the last occasion, the owner of the, your lordship, land, who, your lordship, filed a petition, your lordship, where the, your lordship, the BDO rehabilitated the petitioner herein. Now, your lordship, there was an order of the, your lordship, coordinate bench to rehabilitate or to evict the, your lordship, the petitioner. There is no as such, your lordship, order against the petitioner, but, your lordship, there was an order, your lordship, that to vacate the place where the petitioner residing. But, you know, simultaneously, there was also an order directing, your lordship, the BDO that to rehabilitate the petitioner, and after that, your lordship, vacate the place. But, your lordship, BDO failed to, your lordship, rehabilitate the petitioner hearing, and, your lordship, trying to vacate the entire, your lordship, the resident of the colony, your lordship. Now, your lordship,
As per order of the coordinate bench.
no, your lordship, there is no as such order against the petitioner. There is an order against the, your lordship, BDO to, your lordship, vacate the place after rehabilitating the petitioner. That was the, your lordship, order. I have mentioned and taken the plea, your lordship, in
Why
this petition.
petition has been filed for?
Your lordship, since, your lordship, they are aggrieved with the inaction on the part of the BDO, that the BDO failed to, your lordship, rehabilitate the petitioner herein, and despite, your lordship, there is an order.
Under which act?
Your lordship, rehabilitation, there is just provision, your lordship, under the act, your lordship, and there is actually
Under which act the BDO is entitled, you are entitled to restoration?
Since, your lordship, there is a specific order of the, your lordship, coordinate bench to rehabilitate the petitioner and vacate, your lordship, after
Go before the civil court.
since, your lordship,
Ventilator
since, your lordship, there is a
no urgency, sir.
since kindly, your lordship.
May I be permitted to mention a matter, my lord? This is my intervener application being CAN 1 of 2025.
Give.
My lord, I am also kindly praying for requisition of documents for Court 3. This matter was earlier
Sorry?
from Court 3, from the Court of Honorable Justice Gaurankant, my lord.
Huh.
From requisition of documents from Court 3. It was earlier being heard in Court 3, and I'm being told, my lord, that some documents are still
File is lying where?
in Court 3, my lord. This
They will make requisition.
grateful, my lord. Grateful.
May I permit to mention one matter? Land matter, my lord. Land compensation covered by your lordship judgment. Though two matters, your lordship fixed on 16, my lord. This is a third matter, your lordship.
Identical matters.
Yes, matter. Identical.
Motion. 16th রেখে দিন.
My lord, only inclusion.
Sorry, I will not grant you permission.
Since your lordship only inclusion, already copies are to all the parties.
Hearing or motion matter?
Motion.
Give.
Since, your lordship, the urgency is that, your
No,
lordship,
sir, I understand. I will not
BDO
grant you.
registered the FIR against the, your lordship, petitioner hearing.
Grateful, man.
To you. Yes, call the list. Any other mentioning? No, call the list.
Number 1.
I am appearing on behalf of the petitioner, my lord, challenging the solemn order of your lordship. They have preferred an appeal. My lord,
My lord, on the last petition, but the order dated 7th July, my lordship was pleased to engage me in this matter to represent the contempt.
as per direction of your lordship, my lord, copy of the
Yes, everything
served upon the lord.
everything has been served upon me.
Oh, not an engagement or not done by me. I requested to.
For appearance, lordship. Sorry, my lord.
So,
The instruction is, my lord, that
appeal is pending.
state is yes, trying its luck before Honorable Division Bench. And today it is
What order has been passed? Where is that order, sir, madam?
At my lord page
17.
17.
my lord. Yes, my lord.
17.
And the relevant portion is at page 29. Paragraph 27.
Oh, it is that matter.
My lord,
Subsidy matter.
when your lordship was sitting in Sesquicentenary, my lord, building, this order was passed.
Ashun. It is submitted on behalf of the alleged contemner. দিন তো ভাই since as per since as per
Did I appear for the alleged contemner? On last occasion also, Your Lordship directed service of a copy upon me, my lord. But I am served with a supplementary affidavit which, my lord, contains an unaffirmed copy of the contempt application. It does not have the impugned order. It does not have the order of the Honorable Supreme Court. Does my lord's brief has the impugned order or the order of the Supreme Court? No, I do not want to, my lord, waste my lord's valuable time, my lord. I will try to assist your lordship. My lord will, after the hearing is over, my lord will directive service of a fresh copy. My lord, I can assist your lordship subject to my lord's convenience.
Lordship.
Impugned order is not annexed, my lord. The order of the Honorable Supreme Court is not annexed to my
order
court.
of the Honorable Supreme Court, only the order of this court is there.
It is not there in my brief also, my lord.
Lordship.
Lord, I'll hand up what has been given to me. Lord.
দেখি একবার দাও তোমাকে এই তো মহাবিপদে পড়া
Well, I'll assist your lordship. Lord, I'll not.
সাপ্লিমেন্টারি এফিডেভিট
This has a contempt application, unaffirmed one. I will kindly see.
last page You have not been given with a copy of the contempt application.
Look, this has an unaffirmed copy of the contempt application. That's all I have been given on 7th. Why are we wasting my lord's valuable time? I fail to understand, my lord.
Lordship, every time they are trying to.
আরে এখানে দিন না আমাকে জজ সাহেবের সামনে দিয়ে দিন না
আমার কাছে তো
আগেও তাই বলছেন আমার কাছে নেই
तो मैं तो जज साहब को बोल रहा हूँ मेरे को बोलने दीजिए
कंठरोध कौन कर रहा है आपका
Lordship, every time last since 3 months I have already several copy to their secretary Vandana Yadav, the Supreme Court order in there are 9 numbers of advocates were
বিপদে
questioned.
I'll not waste my lord's valuable time. May I assist your lordship? May I assist? It is between the court and the contemner, sir. Please wait. May I assist your lordship? Lord? May I point out what is the hindrance in compliance? May I get back my copy, my lord?
এই উকিলকে ফেরত দাও
Lordship,
এই এটা উকিলকে ফেরত দাও
I have enclosed only three items of annexer. That is already annexed. I have received their copy. They got 30 numbers of pages.
This has 30
They are
number of
trying-
pages.
No, there is no need of the order of the Supreme Court. That is already served the copy to the contemptor in spite at the time of hearing before the Supreme Court.
Colonel Kylie.
Sorry, sir, please allow me to say something.
Kindly come.
9 numbers of advocates were present there. Mr. Anand Grover was told before the court that we have served your comply your order within forthwith. But in spite of that, they are telling
এই কল্যাণবাবু
they have no,
কল্যাণবাবু
order. They are trying to adjourn the date time to time. I have not annexed the
No, my lord, I said, my lord, I will not be wasting my lord's valuable time, my lord. No, my lord, I said, my lord, I will not be wasting my lord's valuable time.
Lordship, in the brief, already annexed the order of the Supreme Court.
No, my lord will kindly give me 1 minute. Lord, before that, may I?
Lordship. Appear before 11:30, na? Okay.
We are grateful, my lord.
Item number 3, my lord, kindly see your lordship last order. But item number 3, my lord, kindly see your lordship last order.
Lord, I beg to appear on behalf of the state respondents. Your lordship has
But I am
directed me
appearing through
to
virtual mode.
file a report, my lord. सब लिखे थे ना, my lord, my landed junior could not contact with the my lord.
cost has been deposited
Yes, my lord, cost has been deposited.
I am led by him. He is virtual mode. My lord, I am handing up the amended copy of the writ
But,
application along with the cost I have deposited.
Cost has been deposited.
what is this
My lord,
item টা লেখা আছে
one
My
is
amended copy of the writ petition.
item নাম্বারটা লেখা আছে
And only thing we don't know whether the plot has been acquired or not. But that is they have to take the instruction, my lord. But no copy of.
report is there
Lordship kindly excuses me, my landed junior could not contact with the.
Yesterday I contacted with the landed junior and asked whether any affidavit has been prepared or not. I personally contacted with him, the junior advocate.
report is not ready
Report is not ready. Kindly extend the time by 2 weeks, my lord.
But it is a kindly see the matter of old matter, my lord. Old.
Mr. Mukherjee, which is why I have fixed this matter under
No,
the
no.
heading adjourn motion
Absolutely. My only thing they have to take instruction whether my plots of land has been acquired
No,
or not.
I have to file a report. I would file a report. Kindly extend the time by 2 weeks.
WPA 20274 of 2003
আমাকেও বলবি না
WPA 20274 of 2003
তোকে আর কিছু করতে হবে না
Acha. At the time of hearing on behalf of the writ petitioner a receipt showing deposit of cost of rupees 5,000 with the SLSA Government of West Bengal. SLSA Government of SLSA, comma West Bengal, and an amended copy of the writ petition is filed. Have you served the copy of the amended
Yes,
copy?
yes. Yes, my lord.
After, those are taken on record. On being asked by this court, it is submitted by Mr. Mukherjee, duly assisted by his junior, Mr. Bhattacharya, learned advocates, that copy of the amended application has already been served upon the learned advocate for the respondent state. Stop para. You are Mr. Mitro, no?
Lordship,
Mr. Mitro, learned advocate appearing on behalf of the respondent state, submits before this court that the report as called for by this court on 24/6/2025 is not ready. He prays for two weeks accommodation. Stop. In view of such, আজকে হচ্ছে আপনার কত তারিখ? 11 তারিখ তো?
11.
Let the matter be listed on August 1, 2025. Stop para. The report as called for is to be filed mandatorily on the adjourned day. However, an advance copy of such report shall have to be served upon the learned advocate for the writ petitioner at least 3 days ahead. The time limit as fixed by this court is mandatory and peremptory. It is made clear that in the event no report is filed on the adjourned day, this court will proceed with the hearing of the instant writ petition in absence of such report. If you want 2 weeks, I have granted you 3 weeks.
Instead of 1st August, kindly makes it either 4th or 5th August.
4th, my lord, monthly list, my lord.
No,
Fourth is
no.
the monthly.
Adjourned motions are taken up on Friday only.
Lordship, my lord. Then, my lord, 8th August, your lordship kindly makes it 8th.
How long I will extend, sir?
My lord, 8th August.
My 8th August, I will not be here, my lord.
8th August. If you are not there, seek an accommodation.
For the state.
Court who is appearing?
My lord, this is a plot of land lying and situated at Kolkata. My lord, originally this land was.
You want to file an supplementary affidavit?
Because, my lord, yes, I wanted that, but it could not be affirmed due to one of the petitioners is seriously ill and she is like.
Why are you making submission? You will proceed without a supplementary affidavit, or you will?
No, I shall file because.
Then why are you making submission? It is submitted on. You are not ready, sir. Order has been passed on 13th July.
Correct, my lord. The
I
petitioner
take up.
number two. Petitioner number 2 is seriously.
If you are not
cancer,
at all
he is suffering
interested,
cancer.
I will place this matter in the hearing matter. Hearing
My lord,
court.
kindly give 1 week time if it's possible. Otherwise, I shall withdraw to file.
13th June, sir. I have passed the order.
I understand the point.
উনাদের উকিলবাবুদের সুবিধার জন্য আমি মামলাটা করে একজন মশাই রাখছি যাতে তাড়াতাড়ি হয়ে যায়।
No, I am for the municipality. Kolkata municipality.
On behalf of the writ petitioners, an accommodation has been paid for.
I have for the respondent, my lord. I am filing my affidavit in opposition, sir.
You want to file reply again?
My lord, I think, my lord,
Not required.
it has been served upon me yesterday evening. But I will do the case, my lord. I shall formulate the points to and do the case, but I don't think a reply is
Question of
required.
law.
Very
It
good.
is a question of law.
Very good.
My lord, may I just, my lord,
Give me a second then. Sir, madam, one of your friend is making submission before this court. Yes, Mr. Piani.
my lord, the point in short, my lord, I tell your lordship. My lord, there are, my lord, there are two kinds of lease deeds for governing plots in Salt Lake. My lord, in one, lordship will find under clause 2, 17 subclauses under clause 2 of the lease deed. And in another, under clause 2, there are 20 subclauses. So these are the two kind of lease deeds. Now, my lord, over a period of time, this honorable
Those clauses are available in the rules.
in the lease deed,
Lease deed.
parent lease deed, which the government implemented, the governor, my lord, executed in front of the first original
Lease deed for residential purpose.
Yes, all residential.
In favor of the allottee.
In favor of the allottee.
Very good.
Colloquially, we call it as 17 clause lease deeds and 20 clause lease deeds, meaning thereby under main clause 2, there are 17 sub clauses in one part of lease, and another kind of lease under clause 2, there are 20 sub clauses. Now, question had cropped up earlier that whether either of these kind of deeds or any of these has any restrictive covenants upon transfer or sale. Now, this honorable court, going up to the honorable apex court, held that in cases of 17 clause lease deeds, where there are 17 sub clauses under clause 2,
Sorry, it's not expected from you, sir. Kindly. Have some sympathy for the court. Yes.
in kind of cause of 17 clause lease deeds, this court honorable
No, in the self-same deed, both the clauses are there.
There were two kinds of lease deeds.
That you said.
Clause deeds governing certain plots, 20 in certain plots. Now, this honorable court affirmed up till the honorable apex court has held that in cases where these 17 clause deeds are concerned, there are no restrictive covenants upon transfer. Meaning thereby, if I am holding that lease, I need not take a prior permission from the state government if I want to transfer it to Mr. A or B. Now, that is settled. Now the question comes of 20 clause lease deeds. In case of 20 clause lease deeds, there are restrictive covenants upon transfer. So, one initially could not transfer it without prior permission. My lord, then subsequently over a passage of time, government kept on issuing notifications. Ultimately, my lord, a notification came out on 22nd June. 22nd June, my lord, I'll give you a lordship the date. No. Saying thereby that you are allowed to transfer, but upon payment of rupees 5 lakhs per kata. Even then you are allowed to transfer. 22nd June 2012.
5 lakhs per kata to the authority.
To the government. Urban development, state government. Now, my lord, that was also challenged. This honorable court held that yes, payment will be required for 20 clause lease deeds, except two conditions. One, if it is a 17 clause lease deed, this notification will not apply because there are no restrictive covenants. Number two, if there is a will which has been duly provided by a competent court of law following the Honorable Supreme Court in Kailash Chandra Kapoor, that will not apply. So that is the basic structure. But over here, what has happened? It is a 20 clause lease deed. So there are admittedly restrictive covenants. Now, my lordship kindly notes a date. 25th November 1971. I'll take your lordship to the documents. 25th November 1971.
26.
25.
25. I'm sorry. 1991.
71. 1971. But first of all, kindly makes a note that in these 20 clause lease deeds, the restrictive covenants were clause 2 subclause 8, clause 2 subclause 11, and clause 2 subclause 12. 2.8, 2.11, and 2.12.
2.8,
2.11, and 2.12. These were the restrictive covenants upon transfer in all 20 clause lease deeds.
2 clauses. 3 clauses.
3 clauses. Now, my lord, by a order of the government on
what is that? What is this date? 25/11/1971.
In this date, government issued a notification deleting these restrictive, all the 3 restrictive covenants for all leases, for all 20 clause leases. So on 25th November 1971, all the 3 restrictive covenants were deleted by the state government by this notification. So when all these have been deleted, in effect, it becomes a 17 clause lease deed, no restrictions on transfer. Now, by a separate notification on dated 21st February 1986, 21/2/1986, but government issues another order saying that the earlier deleted clauses will be reimposed. What was done in 25th November 71 deleted. By this order dated 21st February 1986, government says that these clauses will be reimposed. Well, now the question that you, apropos the facts of the case, Lordship will decide, consider is whether when this has been reimposed, well, this will have a prospective effect, number one, or a retrospective effect, if not sufficient, exactly stated so in the order. That is number one. Number two, in between this interregnum period, when it was deleted and reimposed, if the government has allowed transfer of certain plots and rights have accrued, whether this order being reimposed can hark back, have a retrospective effect, and again desettle everything which has been allowed. What will happen in the interregnum period? Well, this is the question before your Lordship in this matter. Well, the government says, when I've reimposed it, it has to be read as if, well, it was in force from the beginning. Well, I most respectfully submit that that cannot be. It has to be necessarily prospective unless specifically stated to be retrospective. Number one. And number two, if rights have accrued in the meantime, and if you have allowed that, then you cannot just by a stroke of pen without specifically saying it is retrospective, cancel those rights. So that is the point of law. Well, now I will take your Lordship the documents.
But if my learned friend is relying upon some judgments,
Yes,
if not the judgments are supplied to me, then I can not come ready on those because point has been formulated. 2 points. I say not the first point, retrospective will not apply here because
let him place. Let him place the case. I will give you a chance. No issue.
I think he's caught up in some other.
No, because if
Very good. You will get a chance.
Well, I'll just place the case. Well, it kindly takes page 35. This is the lease deed. Page 35 is the lease deed. Well, kindly notes the name in favor of one Monoranjan Bhaumik. In the first page, Lordship kindly sees, and Sri Monoranjan Bhaumik.
Monoranjan Bhaumik was the original lessee.
Original lessee.
Kollan babu, আমাকে একটু flag গুলো দিন তো ভাই।
Well, this is dated 24th February 1969. বের করেছি, এখানে আটকে যাবো বলবি।
Yes.
Well, now kindly takes page 37. This is a 20 clause lease deed. I shall demonstrate with your Lordship. Kindly takes page 37. But kindly sees clause 2 at the left hand side.
Yes, sir.
Now, below that, Lordship will find 1, 2, 3, 4. These are the sub clauses under clause 2. Lordship has seen it, my lord.
Yes.
Now, my lord, this will continue till 20. If your Lordship, my lord, takes page 6. I'm not so page 40. Page 40.
Yes.
There are 19, there are 18, 19, the 20th clause has gone. not
Total
printed.
29 clauses are there.
No,
Sorry,
that is
19 clauses are
19,
there.
it will be 20. One clause will
Yes.
not type. Then if your lordship kindly sees next page, clause 3 comes in. So it is a 20 clause lease deed. Now, my lordship will find the restrictive covenants at page 39. At page 38, sorry. 28, 211 and 212. Those are the three restrictive covenants. Page 38 is clause 28, subclause 8.
Will you kindly place, sir?
Yes, of course, madam. Clause 8. The lessee shall not assign or transfer the demised land or any part of the demised land and or the structure erected thereon without the previous permission of the government in writing. In case of transfer or assignment of the lease, the lessor shall have the right of preemption, and upon the exercise of this right, the building constructed by the lessee on the land shall be taken over by a lessor at a valuation of the building made by the lessor on the basis of the cost of construction of the building, less depreciation at the usual rate, etc., etc. So, my lord, without prior permission, the plot or the structures erected therein cannot be assigned or transferred. That was the first restrictive covenant.
Permission is to be obtained by in writing.
In writing. Now, my lord, next is page subclause 11. The lessee shall not have the right to mortgage or charge the leasehold interest in the land and or the building to be erected thereon without the previous consent in writing of the government.
Yes.
And 212. If the lessee dies after having made a bequest of the leasehold premises, and if the building thereon, if any, in favor of more than one person, or dies intestate having more than one heir, then in such case the person to whom the leasehold premises with the building thereon so be bequeathed, or the heirs of the deceased lessee as the case may be, shall hold the said property jointly without having any right to have a partition or on the same by meets and bounds, or they shall nominate one person amongst them in whom the same shall vest. So these were the three restrictive covenants. Now, my lord, page 43 kindly comes of the writ petition. This is the order.
By clause, subclause 12,
Lordship.
partition will not be allowed.
That's right. So, all in all, these were the three restrictive covenants on the lessee.
Very good.
Now, my lord, page 43 is the order of the government whereby, my lord, these clauses were withdrawn. On the 25th November 1971. Now, kindly see, government has decided to treat clauses 28, 211 and 212 as reproduced below of all the lease deeds so far executed in respect of the plots of land in sector 1 of the northern Salt Lake City area as deleted on the top. Well, may I place it again? Government has decided to treat clauses 28, 211 and 212 as reproduced below of all lease deeds so far executed in respect of lots of land in Salt Lake sector 1 of the northern Salt Lake as deleted. All other clauses in the lease deeds, however, remains as before.
Yes.
So, my lord, all lease deeds, these three clause deeds so far executed, deleted. Now, my lord, the original lessee at next page, my lord, page 44, my lord, raised a query upon which he wanted to transfer. My lord, sees page 44, the reply of the government. With reference to a letter dated 4/5/73, I am directed to send here with a copy of the GO dated 25th November, in terms of which clauses 28, 211 and 212 of the indenture executed between you and the governor are no longer in force. You are therefore free to transfer the plot to anyone subject to other terms and conditions. So deleted, you are free to transfer. Now, my lord, next page is the, my lord, deed of settlement between the original lessee in favor of his brother Sudhir Ranjan Bhaumik. That is dated, my lord, 11th May 1973, page 45. So, pursuant to the, my lord, permission granted by the government, explicit permission that it is deleted, there is no restrictive clause, you are free to transfer. It was, my lord, assigned by the deed of settlement to my brother, to the original lessee's brother. Now, my lord, Sudhir Ranjan Bhowmik wanted his name to be mutated. He applies to the government. My lord, kindly takes page 51, the reply of the government. My lord, 8th July 1974. With reference to your letter dated 20th June 74, I am directed to say that pursuant to the deed of gift executed and registered in your favor on such and such by your elder brother, in respect of these lease held interest in plot number such and such, the government is pleased to order to mutate your name. So mutation was effected. Now, my lord, the most important document, next page, my lord, page 52, the reimposition of the restrictive clauses. This is dated, my lord, 21st February 1986. My lord, I am placing this, my lord, kindly, my lord.
Give me a second.
I'm sorry.
Kindly place, sir.
My lord, I'm placing in, my lord, kindly marks one or two places. The governor is pleased hereby to withdraw with immediate effect. My lord, kindly marks this. The governor is pleased to hereby withdraw with immediate effect the order issued under such and such dated 25th November 71 of the Irrigation and Waterways Department Government Order relating to deletion of clauses 2A, 211 and 212 of the lease deeds executed on or before the 25th November 71 in respect of lots of land in Salt Lake of the Northern Salt Lake City extension, and it's further pleased to order that the said clause shall remain in force. So withdrawn with immediate effect and they shall remain in force. Well, nowhere stated anything explicitly to be retrospective.
Of course. With effect from that, with immediate effect.
With immediate effect. So, my lord, my first submission will be with immediate effect has to mean the date of the order on which it is issued. It cannot go back to the order, my lord, cannot have a retrospective effect. With immediate effect, lordship will kindly, my lord, my respectful submission conjointly, my lord, read it with immediate effect and shall remain in force. Well, if it was the intention of the legislature or the government that it will have retrospective effect, well, it had to be spelled out in the order.
Yes, sir.
Now, after this, well, kindly marks the date 21st February 1986. Now, kindly see now the conduct of the government even after this order. My lord, kindly now sees now Sudhir Ranjan Bhowmik, whose name was mutated, my lord, he makes a gift deed in favor of his son. That is at next page, my lord, page 53, dated 26 December 2001. After the, my lord, this deletion, this notification that it will be reimposed. 26 December 2001, he makes it a gift deed in favor of his son, my lord, Sanjay Bhowmik. Now, my lord, sir. Now, my lord, these sons, that is Sanjay Bhowmik, but I do not have the document in the affidavit. They have admitted that, but I have stated in paragraph 10 at page 7 that the name of the son Sanjay Bhowmik has also been mutated on 3rd July 2002 by the government. I have stated that in paragraph 10. Paragraph 10, page 7. And they have stated that in their affidavit also, that it has been so done. But I did not have this document, so I could not annex it. Paragraph 10, page 7, kindly see the petitioner states that the name of Sri Sanjay Bhowmik was duly mutated by the respondent authorities as the lessee of the premises by its later dated such as White Damar dated July 3, 2002, and in pursuant thereto, Sri Sanjay Bhowmik constructed the first floor of the existing building in terms of the revised sanctioned building plan obtained by him. So in 2002, after the reimposition of the restrictive covenants, it has been mutated in his favor on the basis of a deed of transfer done earlier. So the deed of transfer.
Give me a
I'm
second.
sorry. I'm extremely sorry.
So with effect from 3rd July 2002,
Lordship.
mutation has been effected in the name of Sanjay.
In the name of Sanjay. But on the basis of, Lordship, kindly excuse me for taking your Lordship back on the
basis of the deed of gift dated 26 December 2001.
When the restrictive covenants as per the, my lord, respondent authorities had already been reimposed. It was reimposed in, my lord,
1986.
So mutation was done. Even after that, no questions raised. Now, my lord, problem is now Sanjay Bhomik, by a deed of assignment, transfers it to the petitioner, which your lordship will find at page 59. 10th June 2009, page 59.
Prior to that, I intend to know one thing.
Lordship.
So far as the deed of gift by Sudhir to Sanjay is concerned, as has been executed on 26/12/2001.
Lordship.
That is after the reimposition of the clauses.
Yes.
At that material time, the Sudhir, the vendor,
Lordship.
took written permission.
No.
No written permission was
Written
taken.
permission, government mutates it, no questions raised.
Very good.
So,
And
I
while
had placed this in my, I'm deeply obliged to your lordship in my respectful endeavor to try and demonstrate that it was the conduct of the government which implicitly showed that it was prospective, not retrospective, the reimposition. Otherwise, the question would have arisen at that point of time that you cannot do it because it has already been reimposed.
No, the conditions was reimposed with effect from 21st February 1986.
Yes.
Am I correct, sir?
Lordship.
Now, deed of
assignment is 2001.
Notification. I'm sorry. Those restrictive clauses were reimposed on 21st February 1986.
Lordship.
Deed of gift was executed on 26/12/2001.
After the
notification.
Yes.
You say that
I say this. But I say that transfer the after the notification gifted by in favor of his son, the son is entitled to transfer after his name is mutated, because once the 3 covenants have been deleted, it becomes a 17 clause lease deed in effect, which does not require any permission for transfer because there are no restrictive covenants. Now, in 86, when they have been reimposed, still they will only take place
do you claim that even after reimposition of the notification dated reimposition of those clauses period notification dated 21/2/1986, the effect of the earlier notification of 1977 74 will continue, 71 will continue?
No, my respectful submission is twofold. One, once in 71, when they were deleted, kindly let us take it part by part. When they have been deleted in 74 or 71, 71, the lease deeds concerned becomes a 17 clause lease deed in effect because 3 restrictive covenants.
I understand.
So I am able to transfer. Number one, I have transferred in favor of Mr. A or B. Government has granted permission. Rights have accrued in favor of Mr. A and B. Now, subsequently, the government reimposes them. My respectful submission is 2. 1, this reimposition has to be prospective. Second, if it is prospective, then only any rights which is accrued in the interregnum period between the deletion and the reimposition, that cannot be touched, number 1. And any rights accrued in that interregnum period, if carried out in future, that cannot be touched by this reimposition. Only fresh transactions can have a binding effect of this. Because I have got a right in the interregnum when there was no clauses, no restrictive covenants. If I knew that, my lord, there are restrictive covenants, I would not have entered into it. So in the interregnum, there are no restrictive covenants. I have my right in favor of me as a
So according to you, the purchaser or the transferee rather,
lordship.
transferee
Did it
got
with the
got the deed effected in his name during the interregnum period.
Yes.
Therefore, the benefit which the transferee got would continue
irrespective
even after the imposition of those clauses.
Well, because of the fact that my right does not springs up from after the reimposition. My right accrues in the interregnum period when there was no restrictive covenants. Now you cannot, after this reimposition, in hindsight, pull it back, have a say that no, since you are now transferring after the reimposition, it is barred. If it was a fresh transfer, now it would have been barred. I would have to take permission. But my right accrues from that period when there was no restrictive covenants. So it has to be related to that period. You cannot buy this reimposition, pull it back over there and see you have to take permission again. But if
So
today,
it is not a case of retrospective or prospective effect.
No, Lord, it is. I'll tell your lordship why. Because, my lord, today, supposing, my lord, after in 21st.
No, your contention, I'm sorry.
I'm
Your contention is that during the interregnum period, a valuable right has been accrued in favor of the transferee, and the transferee will carry the valuable right in respect of the subset property even on subsequent transfers.
My lord,
that is your
absolutely.
contention.
And why I say, my lord, it is in actually a case of retrospective operation being sought to be given. When I take your lordship to the impugned order, my lord, lordship will find what is being sought to be done. My lord, kindly takes this date again, 21st February 1986. My lord, if there is a, my lord, kindly visualize the position that a property has no, my lord, no transfer or no, my lord, proceedings has taken place. It is a property deleted, freshly again reimposed. Now it is being sought to be transferred or, my lord, gifted or whatever. Question of permission comes in. It is prospective, I have to take the permission. But for something which was accrued earlier, when there was nothing, no restrictive covenants, my right has accrued, you have granted me permission. Now why some other submitted is retrospective? Because is that now you say after this reimposition, then no. You are going to do it now after the reimposition. But at that point of time, what was given to you, the permission given to you, now this reimposition will in effect, they say so in exact word, will have in effect that the clauses have been reimposed from 1971 itself. So therefore, the entire chain is wrong. Entire chain you have to take permission. This cannot be allowed. They say so. It will have effect from 1971. That is why I make my submission that this is a case of retrospective operation also. Well, I'll place that from the impugned order. Now, my lord, kindly sees the lordship has sent 59. Page 75 and 77 are my representations.
59 is your deed of
assignment in favor of the petitioner. Now, my lord, then page 75, the petitioners make representation to the authority.
For effecting mutation?
For effecting mutation. 75 followed by 77.
Give me a second. 75.
Now, my lord, nothing was done, but the writ petitioners moved before this honorable court.
Mutation of plot number such and such, consequent of a deed of assignment. And what is the second representation? 77.
77.
Yes.
Now, my lord, nothing was done. Writ petition has moved before this honorable court. Which when the order was passed, his lordship will find at page 86, 18 June 2012.
What is page 86?
Well, the order passed in the earlier writ petition. Since no mutation was not done, nothing communicated, writ petition was moved. It kindly turns to page 87.
Yes.
And kindly sees the third paragraph. Having heard Mr. Such and such, learned senior advocate for the petitioners and Mr. learned advocate of the state, and considering the facts and circumstances of the case, the writ petition is disposed of by directing the respondent number 4 to dispose of the representations dated such and such before the said respondent by passing a reasoned order in accordance with law to be communicated to the petitioners within 8 weeks after giving opportunity hearing to the petitioners and after verifying the records and after causing an inspection of the site in question upon notice. At the time of hearing, the petitioner shall furnish
A reason order was directed to be
directed
passed.
to be passed.
There is the sum and substance.
Yes. Number the reasoned order, well, we have filed, but I've annexed, we filed the written notes of arguments also at the time of hearing.
Order. Give me a second.
Lordship.
Yes.
Well, we filed a written note at the time of hearing, which is at page 99.
Before the authority.
Before the authority. Now, my lord, kindly takes the impugned order, which is at page 105. My lord, is the impugned order dated 23rd June 2014. Lordship.
Yes.
Now, the matter is taken up for hearing in accordance with the order passed dated such and such. Heard him. Mr. Banerjee submits that the mutated lessee Sanjay Bhomik transferred the leasehold plot in favor of the petitioners by executing a deed of assignment dated such and the present petitioner submitted application mutation. He also submits a written statement. From the submissions of the petitioners and on perusal of the records available at the file, it appears that plot number such and such was leased out to Sri Manoranjan Bhomik by registered lease deed executed on 25th February 69. An indenture of transfer has been executed by and between Sri Sanjay Bhomik and the petitioner on 10th June 2009 without obtaining prior permission from the government.
Petitioner is Suresh Bajaj.
Lordship. Without obtaining prior permission from the government and registering the same with additional register of assurance to Kolkata. In terms of clause 28 of the lease deed, kindly mark it. In terms of clause 28 of the lease deed, the lessee shall not assign or transfer the demised land or any part of the demised land and of the structure erected thereon without the previous permission of the government in writing. There is no clause or subclause in the lease deed conferring on the lessee any right to transfer the leasehold interest of the plot to any other person without obtaining prior permission from the lessor, that is the government. The applications dated such and such, these are the representations, are disposed of with the observation that mutation will be allowed in terms of notification dated 26 June 2012. The petitioner may apply accordingly. Now, my lord, kindly sees the language. In terms of clause 2(8) of the lease deed, the lessee shall not assign or transfer the demised land. My lord, in my respectful submission, the moment the authority says in terms of clause 2(8) of the lease deed, he is talking about the parent lease deed of 1969. 2(8) was deleted. So he says actually that when it has been reimposed, clause 2(8) goes back to the original lease deed. But he makes it retrospective. In terms of clause 2(8), he does not say that now it has been reimposed, so you have to take permission. He says in terms of clause 2(8) of the lease deed, you cannot have done that. So in actually he is saying two things. But he is saying clause 2(8) has been reimposed of 1969. And he says that if that is so, the entire transaction in between, that is being made negative.
So so far I have understood. Long and short story of this writ petition is that when the Sudhir Ranjan get the property from his brother,
yes,
he has obtained the property without any restriction.
I'm deeply obsessed.
And
I'm
by way of subsequent
I'm sorry to interject here, my lord, it will also be possible helpful. He has got it without any restriction.
Without any restriction.
And these deeds, my lord, are actually in effect the replica of the other 17 clause lease deeds because there are no restrictions.
I understand, sir. So according to, I believe, according to you, Sudhir Ranjan got the property from his brother.
Lordship.
He got the property without restriction.
Without restriction.
So, on execution of that deed of settlement, according to you, a valuable right accrued in favor of the Sudhir Ranjan.
And that has been acknowledged by the
And-
government by mutating.
Notice, sir, that is good.
Lordship.
According to you, that right passes to the successive purchasers or successive assignee or the transferee, and such and the notification dated 11/5, I'm sorry, the notification dated 21/2/1986 cannot be a factor on such right.
I'm deeply aware.
That is so long and short story of your content, sir.
And when in the impugned order they say that you are stopped because of clause 2 subclause 8, that is reimposition.
Because actor, according to you, after Sudhir Ranjan got the property
Lordship.
and before his transfer, even if any notification regarding restriction has been done, it would have an effect of retrospective operation, which is going to fatter the right
I'm
of the.
deeply aware.
That is your
That is-
basic content.
And they have done it twice. Sudhir Ranjan got it, his son again mutated. I will once again. Bear page 52. Well, may I trouble your lordship once more with the notification at page 52? The reimposition notification.
There is a page number 43.
No, 52, my lord, the reimposition.
Reimposition.
Very good. Hmm.
Yes.
No, no, kindly cease. Please to hereby to withdraw. I've placed this matter on a different aspect. Please to hereby withdraw the immediate effect, with immediate effect, the order dated 25th November 71 relating to deletion of clauses 2.8, 2.11, and 2.12 of the lease deeds executed on or before 25th November 1971. Well, why I am placing this again? Because more or less after 1971, the other plots of lands of lease deeds in Salt Lake were 17 clause lease deeds, not 20 clauses. Till 86 when this was reimposed again.
Till?
This reimposition. So what actually,
I'm sorry,
I'm
I can't
telling you,
follow.
I'll submit it again. Well, more or less after 1971, 72, 73, the other plots of lands in Salt Lake where most of them were 17 clause lease deeds. No restrictive covenants. Till 86 again when this is reimposed. So what actually read with this with the impugned order is being sought to be done is to, my lord, reintroduce with retrospective the restrictive covenants so that the notification of 2012 where you need to pay the amount for that comes into play. The revenue aspect.
Withdraw the immediate effect.
The moment I say with immediate effect, but I subject to correction by your lordship, I cannot touch either the retrospective operation or cannot touch the rights accrued retrospectively. Now, my lord, kindly have a look at the document by which
No, so far as your presentation is concerned,
yes,
what would be your contention? If it be with it immediate effect, it's all right. But in respect of the lease deed executed on or before the 20th November 1971,
yes.
do you want to say that in respect of those deeds where no transfer took place, even after withdrawal of those clauses, it will remain as it is?
My respectful submission is that it has to be read in there are two aspects of it with this. One, the question now, your lordship will decide that already substantial valuable rights have accrued, whether you can retrospectively touch that. Two, this will without doubt have an imposition on those plots where it was deleted, nothing done, no transfers, nothing, reimposed. From now, if you want to do, you have to take the permission.
That I said.
No, that I'm deeply obliged. But what
That I said.
if with those
That in respect, it will, according to you, it will apply in respect of those lease deeds which have been executed on or before 25th November 1971.
Yes.
But immediately after withdrawal of those clauses, no further transfer has been taken. That is your content.
But if transfers have taken place, rights have accrued, and you have accepted the same, Now, Lord, kindly looks at it. This,
Just a minute, sir.
I'm
Let
sorry.
me note.
I'm sorry. উইথড্র হয়ে গেছে, ট্রান্সফার আমার অ্যাপ্রুভ হয়ে গেছে, রাইট? তুমি আবার ওটা নিতে পারো না। উইথড্র হয়ে গেছে, কোনো কিছু করা হয়নি, নতুন ইম্পোজিশন হয়েছে, আটকানো। আমার নিজের কেস না, তোমাদের কেস নিয়ে বলতে পারবো না। তুমি বললে দেখো না, তোকে না। আমি তো আগে দিয়ে দিচ্ছি। Retrospective এটা different আছে। Side করবো না, allow করে চলে আসবে। No disturbance. এটার কেস অন restrictive আছে। Number only 2 minutes. But I will place the impugned order once more. Before that, kindly now visualize the situation at the sake of repetition. There are 20 clause with restrictive covenants withdrawn. It becomes 17 clause effectively no covenants upon transfer. I transfer it to Mr. A. Government allows mutation in favor of Mr. A. Now, Mr. A is under a legitimate expectation that since they've allowed it, I can transfer it to Mr. B also. There are no transfer covenants at all. He transfers it to Mr. B. Government allows that also after the reimposition. Mr. B now thinks that, of course, reimposition has been done, still I can transfer it to anybody. It's a 17 clause lease, no restrictions. He transfers it to the petitioner. Now, government in the impugned order kindly sees at page 105. Kindly sees only one line of the impugned order at page 105. But kindly see the second paragraph at page 105. From the submissions of the petitioners and on perusal of the records it available, it appears that plot number such and such was leased out to Monoranjan Bhomik, original lessee, by registered lease deed executed in 69. An indenture was transferred between him and Sanjay Bhomik. Now kindly sees Monoranjan Bhomik in 69. An indenture of transfer and executed by and between Sanjay Bhomik and the petitioner in 2009. Nothing stated what happened in the interregnum. So, the picture is given as such. Monoranjan Bhomik in 1969. Suddenly, Sanjay Bhomik transfers it to petitioner. Then kindly sees the next line. Without obtaining prior permission of the government and registering the same, in terms of clause 28 of the lease deed, the lessee shall not assign or transfer.
According to, I believe, Mr. Biyani, it is your contention that the authority has consciously suppressed the transaction between Monoranjan and Sanjay.
But probably has forgotten.
That is your, that is
Probably authority has forgotten to mention.
very good.
Lordship.
Forgotten.
Lordship.
That is in a very sweet tongue. Or in a polished way. But is it your contention that when
Because
Manoranjan again transferred to Sanjay,
Lordship.
and when if Sanjay applied for mutation,
Lordship.
and that has been effected,
Lordship. Then if those were
it is by that act, the government has either recognize your contention,
Lordship.
or by their action waive the
I'm coming. I'm
contest.
extremely obliged. But my submission is not either or, it is both. The government has recognized me and waived that. So if government has waived that, my lord, under section 62 of the Contract Act, it is a novation of contract, it cannot be reimposed in those cases. Well, I'll cite that decision also at the time of citing to your lordship. It is because section 62 does not only say it cancels, it is also modification or alteration. Contract. It is also modification or alteration of the contract. That cannot be reimposed again with retrospective effect. Novation. It has been modified. Novation. Now, my lord, one thing is very important for your lordship to kindly consider. My lord, they have said, if your lordship has seen in the impugned order that you are free, even after all this, you are free to transfer in terms of the notification dated 22nd June 2012. I'm sorry, lordship note question.
Yes.
Last line is 22nd June 2012 at page 105. If you apply according to the notification of 22nd June 2012, you will be allowed the mutation. And this is the last paragraph at page 105.
The application dated such and such, dispute with the officer of administration will be in terms of notification not dated 22/6/2012.
Lordship has seen that?
That is at page number?
That is at page number 106. Let me replace a few parts of this. It is important. Kindly see clause 2. It has come to the notice of the government in the UD department that in many cases possession of plots is transferred to third parties on the strength of various documents such as general power of attorney, agreement of lease, tenancy, and will to strangers, and that those such documents do not amount to a transfer of lease of law.
Oh, it is with regard to payment of permission.
Payment of permission fee. So, my lord, now kindly sees
transfer fee at the rate of rupees 5 lakh per kata.
Right. Well, this was subsequently revised to some additional amount 6 lakhs or something. Now, my lord, kindly now sees what is the bone of contention. Bone of contention is the reimposition you cannot transfer. No. Reimposition, retrospective effect, we will allow you to transfer, deposit the fees. It is not
that will be governed under the original clauses. I will grant permission subject to the notification.
Subject to condition.
So, if this is, I respectful submission, this is contradictory. Because if you are relying on clause 2, subclause 8, restriction, then you cannot say, I'll transfer it with this, pay me money and I'll transfer it.
Why?
Because prior permission was not obtained. 2 subclause 8 says you have to obtain prior permission.
No, which is why this notification has been issued.
You are granting post facto approval?
Absolutely.
Now, this notification, this honorable court has held, has no application in respect of 17 clause lease where there is no restrictive covenants. So, now third submission, you now by this way cannot apply this in those cases and ask for the money to revenue for this, allowing this. This has no application with regard to 17 subclause lease. Order passed, not appealed against, attained finality. And not passed now. Passed about 10-12 years back. I've got that decision also. So, my lord, this is in short my respectful submission. Now, they have filed an opposition. Opposition to them. My lord, I will not trouble you, lordship, everything, but kindly see what they say in the opposition. Basically, what they say in the opposition. But kindly takes page 11. The first page, this is the affidavit on opposition. I'll come to that later, but page 11 is the report. Instructions in the statements of fact. Kindly takes that once at page 11 of the opposition.
Yes.
Kindly takes clause 3. No, clause 2. On 4th May 1973, Lease Sri Manoranjan Bhomik applied for permission for transfer of his said plot to his younger brother, Sri Sudhir Ranjan Bhomik. On the above request, the government then informed the lessee that as per the notification dated 25th 11/71, clauses 28, 211 and 212 of the lease deed are no longer in force and free to transfer the plot to anyone. After some time, this above GO has been withdrawn by the government by issuing an order dated 21st February 86. Thereafter, the aforementioned order has been withdrawn with immediate effect and the prohibited clauses shall remain in force. That means the plot is under 20 subclause lease deed property. So it has to be prospective. You cannot touch my accrued interests. Now, my lord, kindly takes page, next page. Kindly takes clause 15. On 3rd August 2009, Sri Suresh Bajaj and Sangita Bajaj petitioners have applied for mutation of the above plot on the basis of a deed of assignment executed by the lessee Sri Sanjay Bhomik and duly registered without prior permission from the lessee government, which is violation of clause 28 of the lease deed.
You are referring which code clause?
Page 12, clause 15.
Oh, clause 15.
Lord, sir. On 3rd August 2009, the petitioners have applied for mutation on the basis of deed of assignment executed by the lessee Sanjay Bhomik, duly registered without prior permission from the lesser government, which was violation of clause 28 of the lease deed. Now, my lord, kindly now see only next page, one very important paragraph they have stated, paragraph page 13. Or I would say this is an admission. Kindly sees the third paragraph of point number 17. The GO number such and such, Lordship has got it. The GO dated 25th 11/71 was withdrawn by the government by issuing another GO dated 21st February 86. It is clear that the aforementioned order has been withdrawn with immediate effect. Well, kindly marks it, has been withdrawn with immediate effect, and the prohibited clauses shall remain in force. That means the plot is under 20 subclause lease plots and transfer fees will be applicable. Has been withdrawn, shall remain. I have no quarrel with this. I accept this. Has been withdrawn, shall remain in force. But my lord, as it has fallen from your lordship, what happens to the interregnum period and the rights accrued when it was not in force? Can you, by this reimposition, without stating it to be specifically retrospectively that effect, go back to that and my lord, take away my rights? In my resolution, it cannot be, and that is what
I understand. Your contention when the purchase the property, there's is practically a freehold land.
Practically a freehold land.
Freehold land. Thereafter, the moot question arises as to whether by reimposition of the restrictive clauses, you can put a fetter on that.
Which has accrued when there was none.
When?
When we fetter on the rights which had accrued when there was no restrictions.
Absolutely. That is the main question.
My lord, my learned friend wanted the citation.
No, prior to that, I have an important case. You have to wait, sir.
Lordship. No, I'll not place my lord. He will be, I think, coming. Very good. No, I understand.
So, Nilotpal is so important.
Grateful, Milord.
Come to me.
No. What more, Milord? Lordship was. I did not quarrel, Milord. My lord will kindly not misconstrue.
No, sir. No question of misconstrue.
But I have shown that I was not.
আপনার ওই আমি কপি দিয়ে দিয়েছি আসুন ভাই
May I?
Mr. Chatterjee, learned advocate appearing on behalf of the
সুপ্রিম
আর বলতে পারবেন না, কপি পেয়ে গেছেন, আজকে কপি নিয়ে ওনার গ্রিভান্স ছিল, কপি দিয়ে দেওয়া হয়েছে। Anything more, Mr. Biyani?
Well, I'll just, if you want, Lordship, Honorable, because I think it will help Mr. Banerjee wanted to.
No, you want to rely upon any judgment?
Citations, my lord, so that he can also take them down.
Please,
Lordship.
Mr. Banerjee, please take his seat.
No, first to my day. My lord, on prospective operation, my lord, 2 decisions, and on my lord, 1 on this, my lord, contract act. Prospective operation টা দে, এটা দে আমাকে। বলছি দাঁড়া। 84 এই হচ্ছে তোর 281 বের কর। এই তো my lord, this is my lord, 1984 volume 3 Supreme Court cases, page 281. 84 3 SCC 281.
Page 281,
Lordship.
paragraph
15. Well, may I place it? It may be pointed out at the very outset that the Parliament, as also the state legislature, have plenary powers to legislate within the field of legislation committed to them, and subject to certain constitutional restrictions, they can legislate prospectively as well as retrospectively. It is, however, a cardinal principle of construction that every statute is prima facie prospective unless it is expressly or by necessary implication made to have retrospective effect. But the rule in general is applicable where the object of the, this is somewhat against me also, because I'll try to distinguish. But the rule is in general is applicable where the object of the statute is to effect the vested rights or to impose new burden or to impair existing obligations. Unless there are words in the statute sufficient to show the intentions of the legislature to effect existing rights, it is deemed to be prospective only.
So this line is in your favor.
This line and the
Unless
earlier
there
ones.
are words in the
I
statute
want kindly see,
sufficient
but the
to show
rule is kindly
the
see this.
intention of the legislature to affect existing rights, it is deemed to be prospective.
Also the line earlier kindly sees, but the rule in general, it is deemed to be prospective only unless specially stated to be retrospective then. But the rule in general, this rule in general is applicable where the object of the statute is to effect the vested rights or to impose new burden or to impair existing obligations. Over here, vested rights and existing obligations. That you cannot do.
Very good.
The next is, my lord, boita de. বলছি 1980 volume 4 Supreme Court cases, page 354.
Just a minute, sir.
Lordship.
Let me note.
T4 in 354, para 21.
Will you please tell me the citation?
My lord, 1980 volume 4 Supreme Court cases, page 354. Paragraph 21. At page 361, my lord, paragraph 21.
Yes.
Before dealing with the contentions canvassed, we may remind ourselves of some well-known principles of interpretation in regard to the retrospective operation of statutes. Then kindly see, as a general rule, a statute which takes away or impairs substantive rights acquired under the existing law is construed to have a prospective operation unless the language of the statute expressly or by inevitable intendment compels a contrary construction. Kindly see again. As a general rule, a statute which takes away or impairs substantive rights acquired under the existing law is constituted to a prospective operation unless the language of that statute expressly or by inevitable indentment compels a contrary construction. But over here, it not only impairs, it also takes away my right. So therefore, it had to be specified in that government order that it in these cases also it will have a retrospective operation. Well, I make this submission consciously, it was not done so, but it was not the intention at all that those affected, the rights already accrued will be affected. This intention has come in, my lord, after the notification of 2012. Well, kindly see the next line, it also makes a distinction in this paragraph. But this presumption as to prospective operation of a statute does not apply to an enactment affecting procedure or practice such as the Code of Civil Procedure. The reason is that no person has a vested right in the course or procedure. So if it is a civil procedure code or any procedural aspect, it may go back, it may impair, but otherwise it cannot.
General President, indeed seems there to be that alteration in the procedure always retrospective, unless there are
alterations
some,
of a procedure such as in civil procedure code.
but in case of substantive law, it is not.
Cannot. But I've also found that it may be submitted or it may fall from your lordship that it is in these cases that it is allowed, but not in substantive law. It is allowed in procedural law, not in substantive.
That is it.
Now, my lord, one judgment on this similar Contract Act, the novation. Wait a minute. Well, this is 2017, Volume 1, Supreme Court Cases, page 487. Paragraph
2017, Volume 1, SCC 487.
487, my lord, paragraph 15. Well, I'll tell your lordship the page number because it is a longish judgment. বুঝেই তো পাচ্ছি না 12 তে বলেছিলি না বলো
এটা ফ্ল্যাগ দেখি ভাই
at page 512. Kindly takes page 512.
Yes.
Well, paragraph 15 before that, paragraph 14, well, kindly see section 62 has been set out of the Contract Act.
Yes, section 2 has been set
62 has been set out. If the parties to a contract agree to substitute a new contract for it, or to rescind or alter it, the original contract need not be performed. Now, my lord, kindly see paragraph 15. Under section 62, apart from novation of a contract and rescission of a contract, alteration of a contract is mentioned. Alteration is understood here in the facts of the present case, in the sense of amendment. Well, I say the same thing applies here. It is a settled law that an amendment to a contract, being in the nature of a modification of the terms of the contract, must be read in and become a part of the original contract in order to amount to an alteration under 62. This is clear from such and such. Now kindly see subplacetum 15. The effect of the alteration or modification is that there is a new arrangement. In the language of Viscount Halden in Morris versus Barron, a new contract containing as an entirety the old terms together with it as modified by the new terms incorporated. The modifications are read into and become part and parcel of the original contract. Those of the original terms which cannot make sense when read with the alterations must be rejected. But over here it has been altered. Now, when it is proposed, of course it will have an effect. My lord, as it has fallen from your lordship, I repeat, my lord, I say this is submitted the sake of repetition. In those cases,
where no transfer took place.
Well, only one decision, because I made this submission that this 17, well, this notification of 2012 will not apply to 17 clause lease deeds. Well, that has been held by this honorable court. Well, that is, my lord, that is the last judgment I have. Well, that is, my lord, 2013. 2012, 4 Calcutta High Court Note CHN, page 539. Well, a very short judgment.
Page number?
539.
বইগুলো নামিয়ে দিন তো। Yes.
Well, kindly see the first paragraph, it will be clear. Several residential plots in Salt Lake Township were leased out by the state government to various lessees. Two types of model lease deeds were prepared by the state government for transfer of those plots of lands on lease. One of such model deeds contained 17 clauses and the other set of model lease contained 21 clauses, or it will be 20. This is a typing mistake. So far as the lease deeds containing 17 clauses is concerned, no restriction on transfer and assignment of the leasehold interest was imposed on the lessee. Only restriction was imposed on subdivision and subletting the demised plot of the land. However, restriction on transfer and or assignment of the leasehold interest by the lessee in favor of any stranger was imposed by the lease deeds containing 21 clauses. 20. Here in the instant case, then it is not required. On perusal of the said lease deed, the court finds that the said lease deed contained 17 clauses and no restriction was imposed on transfer and on the assignment of the leasehold deed. Then kindly, my lord, skips this. These are the factual aspects. My lord, kindly takes the next page. My lord, this paragraph starts with, in this connection, Mr. Mahato submitted. My lord, about 4 or 5 paragraphs at the next page, my lord. In this connection, Mr. Mahato submits that the petitioner's application for mutation. The mutation will be considered by the concerned authority in the light of the notification dated 25th June 2012. The said notification prescribes imposition of transfer fees at the rate of rupees 5 lakhs per kata. Let me now consider as to how the petitioner's right to get their names mutated on as a transferred lessee can be guided or controlled. Paragraph 2 of the said notification, in my view, is relevant for the aforesaid purpose. It says it has been set out. Then it kindly sees, my lord, on perusal of the said notification, particularly the provision contained in paragraph 2 of the said notification, this court is of the view that the said notification is applicable only in case of lease deed which contains 20 clauses wherein restrictions on transfer is imposed. Since the parent lease deed which was executed is 17 without imposition of transfer, the notification dated such is considered as no application as far as the petitioner's application mutation is concerned.
It is 17 and 21.
Yes, but this notification will not apply in case of 17 clause lease deed.
According to you, when it becomes a 17,
It was withdrawn, it
20
becomes
became
17.
17. That is the
Now,
case.
reimposition again with accrued
so by
interest cannot
withdrawal you have made it 17. So cannot made it again 20.
where my rights are already accrued.
Accrued.
And those are my submissions.
May I come back on Monday, my lord?
Yes, right.
Oh, সবাই জানে।
This court has heard Mr.
Much obliged.
বইগুলো আমার চেম্বারে পাঠিয়ে দিন।
মানে দাঁড়াও না অনেক অ্যাক্সিডেন্ট আছে তুই আমি তোকে ডেট বলে দেবো 23 করলে তোর অসুবিধা আছে মানে instead of 18 মানে 18 19
No, 18 he will give it. Ask your junior to remain.
I'm deeply obliged to you.
Lord, I appeal for the
I am appealing for the state.
My lord,
occasion.
I am appealing for the corporation.
6-7, my lord. In respect of my lord, the steps and property, my lord, one, my lord, petition was filed for seeking permission to the my lord.
Let the file be placed first.
এটা না ওইটা
You have filed report. Report has been filed.
my lord, that was not available in the record, my lord, on the last occasion. Your lordship was pleased to direct for reconstruction of the report, my lord.
Liberty is given to the respondent number 5 to 6. 5 and 6 to submit a report. Who is respondent number 5 and 6? একটু বার করো ফাইলটা দিন তো WPA 162888 who is appearing
16288.
16288 who is the respondent of 5 and 6
5 and 6, my lord, the managing director, commissioner, 5 is not there, my lord.
কি বাবা 16288 এর রিট পিটিশন একবার দেখি ভাই
এটা কি 6-7 হচ্ছে? আমরা মিলট 6 and 7 মিলট দেখি
1688 টা কোনটা আমাদের আজকে
মিলট 6
item number 6
item number
item number 6 who is respondent of 5 and 6 Mr. Somnath Ganguly and Mr. MS Kolpita Pal
মিলট
5 and 6 is not, my lord, in the writ petition 16288 because only 4 respondents are there. My lord, it is, my lord, with regard to wetland.
But I have been instructed to appear in the matter, my lord, in respect of, my lord, WPA number 21159.
এটা কি
And
ভুল
will
টাইপ
you
হলো
report to that effect?
it reveals that the instant matter East Kolkata West Management has functioned এবার ফাইলটা দিন না আমায় দেখতে আমি বুঝে এমন হচ্ছে ভুল হলো নাকি এটা টাইপিং
Well, this is the report.
16288
Time নেই? তোকে দরকার নেই, তোর পুরো আছে তো। এই তো sign করা আছে। Well, this is the report, your lordship. Direction, Miller, this report has been filed. Kindly looks at the report, Miller.
5 নম্বর তো করে গেল হ্যাঁ ইট ইজ দেয়ার ওগুলো ওকে দেখান এই তো 5 আর 6 আছে তো নেই বলছেন কেন
আমাদের কত?
আমরা item number 7
16288 দেখান ওগুলো ওকে
Oh, they have been, my lord, added there subsequently.
Why are you making confusion, sir?
My lord, they have been added, my lord.
Then
আমার কোথায়?
Because, my lord,
East Kolkata Wetland Management Authority, who is appearing?
Lord, I am appearing, my lord.
Mr. Somnath Ganguly and MS Kolpita Pal.
Lord, I am appearing on, my lord. I have been instructed to appear, my lord.
On the last occasion, they appeared.
Well, last time I also appeared. I appeared, my lord, on virtual mode.
You are Mr. Mitro.
Lordship.
You appeared in
With my landed junior.
you appeared Rama, you appeared on behalf of the state.
No, my lord, on behalf of the authority. And on behalf of the authority, my lord, I have filed, just now I have filed the report, my lord.
You are also representing the state.
Lordship, my lord.
Very good. You have filed the report.
Just now, my lord, with presidential lordship direction, my lord.
দেখি ভাই রিপোর্টটা দেখি report in the form of video 16288 very good wait then
আমাদের আগেরটা দেয়া আছে পরেরটা
একই রিপোর্ট সেম রিপোর্ট
আচ্ছা এবার ওইটা একটু ওই রিট পিটিশনটা দিন তো ভাই আর একটা রিট পিটিশনটা রিপোর্টটা রাখুন ঠিক আছে এখানে হচ্ছে রেসপন্স নাম্বার 226 কি আছে দেখি 226 ইস্ট কলকাতা চেয়ারপারসন মেম্বার সেক্রেটারি চিফ all East Kolkata.
Yes.
The report, the ACO report, the such report is not available in the file. Department to trace out. Direct to reconstruct. কি রিপোর্টেরও দেখা যাক on behalf of East Kolkata in WPA 21159 of 2023, who is appearing?
Lord, I am appearing.
You have filed a report,
The lordship, my lord.
new report.
Same report, my lord. Same report.
Oh,
it is with regard to, my lord, the declaration of
on the last occasion, it has been submitted, the report has been filed,
Yes, yes.
and direction was filed, therefore, Either to trace out the
I
report.
have filed the
You have filed the report. Very good.
Kindly looks at the report, my lord.
No, let me hear him.
My lord, this
Which case I will take up?
my lord, 21159, because my lord, it is with regard to the my lord main writ petition. Unless it is my lord disposed of, the other matter cannot be my lord taken up.
So I am taking 21159.
21159.
Give me a second, sir.
Right, 21159, wetland.
Yes.
My lord, this writ petition, my lord, pertains to my lord declaration of wetland by the authority in respect of the land purchased by the petitioners, and my lord, by notification, my lord, which was published in the year 2006. My lord, the petitioner is only concerned with the purchased land of the petitioner, not the my lord entire area. And my lord, this my lord area has been declared as wetland. My lord, East Kolkata wetland. That means in Bengal, my lord, জলাভূমি। পূর্ব কলকাতা জলাভূমি। My lord, it relates to the land, my lord, surrounding, my lord, either, my lord, pond, water body, or, my lord, downland. So, my lord, may I first place, my lord, before lordship, my lord, the annexure P1, my lord, all the deeds purchased by, my lord, the petitioners, measuring, my lord, all total 4.27 acres. That is, my lord, at page 39, starts from up to 199. My lord, kindly have a look. One of the deed, my lord.
Page number, sir?
Page number, my lord, several deeds are there. Well, page now it starts from page number 39 to 199. Lordship, kindly take up only one deed, my lord, because all the deeds are identical.
How many petitioners are there?
My lord, the company, my lord.
One company. Very good.
Now, my lord, kindly have a look, my lord, page 46. My lord. That is, my lord, the schedule of one of the, my lord, deeds.
Yes.
My lord, your lordship will find, my lord, the schedule A referred to above, district of 24 Pavana South, PS Bhangor, now KLC, ADSRO Bhangor under Beota 2 number Gram Panchayat Mauja Pulveria, jail number 7, RS Khotian number 558, LR Khotian number 1200, Hal Dag numbers 554, Toji number 147. My lord, the classification of the land has been described as, my lord, Sali. Measuring, my lord.
Schedule A is the total land.
No. There are several deeds. My lord, I am showing only my schedule of one of the deeds.
What is Schedule A?
Schedule A, my lord, that is a part of the purchase property of the petition.
And what is Schedule B then?
That is also, my lord, the part of the property.
Acha.
Because, my lord, will find, my lord, Hal Dag number 554.
So in Schedule A, you purchase 37 decimal, and in Schedule B, 2 decimal. Total 39 decimal of land you have purchased.
All total purchase, my lord, 4.27.
No, by this deed. By this deed, you just come down.
Yes.
There is another table there of their land by 2 schedule. Total sold area 39 decimal. Very good. Then what happened?
No, my lord, thereafter, my lord, after purchasing this property, my lord,
one is Sali and another is Danga.
So not my lord, any bill, pond, or like any, my lord, water bodies there. Now, my lord, kindly have a look, my lord, the next annexure, that is, my lord, the my lord, Land Reforms Authority also, my lord, mutated the name of
page,
my lord, 200, annexure P2.
200.
200.
এই আমাকে একটু এটা দিন না ফ্ল্যাগটা দিন ভাই What is page number? Oh, a certificate of mutation.
Certificate of mutation, my lord. Page number 200.
এইখানে দিন আমার কাছে এখানে রাখুন। একটা আমাকে দিয়ে রাখুন ব্যাস। দাও এটা দিন আপনি রাখুন, এটা রাখুন, ব্যাস। Yes.
My lord will find, my lord, this is in the name of the petitioner Starling Invest Private Limited.
হ্যাঁ
That is, my lord, address is there. Reference, mutation case number, such and such.
Total is 4.27 acre. In
4.27.
plot number 520, 521, 554 and 674.
And my lord, kindly, my lord, note in, my lord, date of the mutation is 36/2011. Because, my lord, date is the important, my lord, in this case.
30th June.
30th June 2011.
Yes.
Now, my lord, kindly come to, my lord, the next page, 2000, my lord, 201, 202.
202.
2. This is the, my lord, RS spot. 2002, 202, my lord will find 595, third, serial number third. 575. In Bengali it is written.
571.
575.
571 or 5?
My lord, 575.
No, no. How can it be? It is in Bengali, no?
Bengali.
500, 780, 781 and 500, 571. 571.
571. My lord, the classification of the land has been recorded as Danga.
571 is your plot?
My lord.
No. Your is RS plot.
But I will show you lots of, my lord, from the other deeds, because, my lord, a huge land was purchased by the petitioner.
520 and 554. But mutation is in respect of 520, 521, 554 and 674.
Well, this is the, my lord, LR.
Then how do I correspond?
My lord, that has been, my lord, stated. I will show you lordship later on, my lord.
Anyway,
My lord,
so according to you, 571 is a Danga.
Danga, my lord, measuring 0.07 acres. And, my lord, 572, that is recorded as Sali. Now, my lord, kindly come to, my lord, page 203. All these are the purchase land of the petitioner. 570, that is, my lord, recorded as Sali. Now, my lord, kindly have a look, my lord, page number 210. This is the, my lord, CS watcher.
Yes.
The last one from the bottom. My lord, 674, that is, my lord, classified as Sali. This is also, my lord, the purchase land of the petitioner.
674.
670. Now, my lord, page number, my lord, 214. Oh, that is 674, that is Sali. Same portrait. Same
214.
674, my lord, that is recorded as Sali in CS portrait. Page number 240. So, my lord, kindly have a look, my lord, annexure P3, page 215 to 224.
215.
To 224. These are, my lord, all the, my lord, government revenues for using and occupying the land that has been, my lord, charged, and the petitioner has paid all the, my lord, government revenues to the Land Reforms Authority. So, my lord, kindly have a look to, my lord,
Khajna receipt.
Khajna. Now, my lord, kindly have a look, my lord, page 224. My lord, this was, my lord, charged for, my lord, using as commercial purposes.
Very good. Then what happened?
224, lordship, kindly have a look, my lord. That is
Ah.
in the name of the petitioner, and, my lord, the charge is, my lord, high, because, my lord, it was charged or for using the plot or subject plots as commercial purposes.
Where will get that?
My lord, the charge itself, my lord, it has been charged 34,000. At the bottom, your lordship will find, my lord, 34,482.
Yes, I got it.
Well, that is, my lord, you excessive, my lord, charges on the base as a, my lord, same as, my lord, using as commercial purposes. So, my lord, the government authorities also, my lord, accepted the position that the land in question is a highland, and it is, my lord, fit for, my lord, using as commercial purposes. That's why, my lord, the land has been mutated in the name of the petitioner, and, my lord, the taxes has been imposed as a higher rate for, my lord, using the, my lord, the same as commercial purposes after purchasing of the property. Now, my lord, kindly have a look, my lord, annexure P4, page 225. This is, my lord, the LR record. Lordship, kindly have a look, my lord, annexure P4, page 225. My lord, it is in the name of Starling Finland Private Limited. That is the petitioner before lordship.
Yes.
My lord, tag number 520 Danga, 521 Shali, 554 Shali, 674 Shali. So, my lord, my humble submission before lordship, my lord, in the CS record also, my lord, the land purchased by the petitioner is recorded as highland. In the RS record, my lord, it has been recorded as highland. And, my lord, in the LR record also, record of rights, it was, my lord, recorded as, my lord. 674. My lord.
property, and your submission is that those are basically Danga and Sali.
Sali.
These are the short and long story of your arguments so far as advanced. Very good. Then
Now, my lord, I am, my lord, only, my lord, showing your lordships the schedules of, my lord, all the lands, because your lordship will come to the finding that how much land I have purchased. My lord, 5 deeds are there. My lord, first, my lord, page 46 of my writ petition.
you tell me how much land you have purchased.
My lord, all total 4.27 acre.
4.27 acres you have
5
purchased.
deeds.
Purchased. Why?
5 deeds. All, my lords, the same date. So all are same dated.
That is page number 39 to 199.
39 to 199.
Very good. Then what happened, sir?
Then, my lord, kindly come to, my lord, page number, my lord, 225, which I was showing your lordship, my lord.
Yes, there is a LR Porcha
LR Porcha.
that you have
Now, my
shown.
lord, then now, my lord, the date of, my lord, preparing the Khotian is 17/1/2022. This is very vital.
Huh.
Because in the LR, my lord, record of rights, the Khotian have been, my lord, made the difference from the RS and Cs. The Khotian number, which was recorded in, my lord, RS Porcha and CS Porcha, that has been, my lord, changed in, my lord, LR Khotian, LR record. That has been, my lord, prepared on 17 January 2022.
Hmm.
And on that date, my lord, my name, the name of the petitioner has been, my lord, recorded in the records of the Land Reforms Authority, showing the land of the petitioners as Danga, Sali, Sali, Sali.
Very good, sir. Then what happened?
Then, my lord, the petitioner came.
Why you are aggrieved?
My lord, I am aggrieved by this notification. That is, my lord, at page 226, annexure P5.
Yes.
This is the, my lord, Gazette notification, which was published on, my lord, March 31, 2006, by which, my lord, the land of the petitioner, as well as, my lord, huge area has been declared as, my lord, East Kolkata wetland area.
Hmm.
Bengali, which is known as, my lord, Purbo Kolkata Jalabhumi.
Yes.
My lord, this fact was not known to the petitioner, that this notification was, my lord, published in the Kolkata Gazette declaring the purchase land of the petitioner. As the petitioner, my lord, after purchase of the property, my lord, took every steps so that, my lord, the property can be developed, and, my lord, the commercial activities can be commenced, my lord, on that.
No, which one is earlier? 2006 notification is earlier.
2006 notification is earlier, because, my lord, 2000.
Now your plot numbers come under this notification.
This notification will not came into force with retrospective effect from 16 November 2005.
16 November 2005. Yes.
16 November 2005.
Yes.
But after that date, my lord, I purchased the property. I, my lord, mutated my name.
By this notification, all transactions have been prohibited.
No, my lord, the property, my lord, cannot be, my lord, purchased.
No, what is the effect of this notification?
The property cannot be, my lord, developed. Property
Where
cannot
is
be, my lord,
experiment
used.
to a conversation and management of issue for matters current. No, what I'm on by what is the effect of this notification?
My lord, by this, my lord, notification, my lord, I cannot, my lord, use that land for commercial purposes or any other development purposes.
So what is the illegality then?
My lord, that is, my lord, my case, my lord, because I, my lord, purchased the property when, my lord, it was the classification of a highland. That has been recorded by the Land Reforms Authority.
But it is still within the notification.
That is, my lord, I have, my lord, challenged so far my land is concerned. My lord, I am not the entire notification I have challenged. I have not challenged, my lord, not the entire notification. My lord, maybe there are, my lord, water bodies.
What is your prayer then? to exclude the area from the notification.
My lord. My lord, at page, my lord, 35. Edit in the nature of mandamus to issue commanding the respondents and each of their main agents and associates from giving any effect or further effect of the purported gazette notification dated 31st March 2000 over the.
It has already been taken effect.
Well, that's why, my lord, that is, my lord, I am challenging because it is, my lord, not applicable in my case.
Sir,
But it is a.
under which provision of law it will be excluded then?
My lord,
Under which provision of law it will be excluded?
yeah, my lord, in the act itself it is stated, my lord, it can be included or excluded.
No.
It can be included, it can be excluded.
By this notification which was published on 31st March 2006 with retrospective effect from 16 November 2005, according to you, the schedule of lands are there
My lord.
Yes.
and your property falls under the schedule.
Inter area, Kulberi area.
Your property comes under this those schedule.
My lord.
Then how the
My lord,
court will
if
help
it
you?
is- my lord, if it is invalid, if it is illegal, so far the land of the petition is concerned.
Where is the illegality?
my lord,
I fail to understand.
I have got every, my lord, right to challenge that, my lord, notification. Only, my lord, so far my land is.
If you want to challenge the vice,
Yes.
on which grounds, please kindly tell me
My lord, I am-
why it
that's
is
why,
required
my
to be quashed.
No, that's why, my lord, I was showing your lordship, my lord, all the documents. That it never possesses the. my lord-
No, tell me one thing. This notification prohibits any transfer.
No transfer, only development.
So don't develop.
Well, I have purchased the property for doing commercial activities.
Why a
there.
purchase?
Well, they are charging commercial.
When there is a notification, this area is under this notification. Why a purchase? You have taken the risk.
I was not aware.
The ignorance of law is no excuse, sir.
But, my lord, so far my land is concerned, my lord. This
No, what material? You have shown the document of your title. I am satisfied.
Not title, my lord, classification also.
What are the deeds?
My lord, deeds, my lord,
Relating to the title,
title and classification. Also.
and you have shown the record of rights, showing the classification of lands. Am I correct? And you have also shown that the purchase portion has been muted in your name. You are paying khajna. Now,
doing
those
commercial
those cannot be a ground for cancelling the notification.
My lord, those, my lord, the taxes are
Yes, sir. এই দেখি রিপোর্টটা দেখি ভাই কি দিয়েছেন
My lord, taxes
First
are
thing, your lordship
No, my lord,
considers one thing.
এই একবার রিপোর্টটা দিন ভাই এটা
my lord, I will
1159
I will show your lordship, my lord, the judgment of the policy of the government, my lord.
দেখি দিন what is your report, sir?
Just a minute, I have handed over.
এটা দেখুন ওকে দেখান না এটাই কিনা
এই তো এটা রিপোর্ট
this report will be treated as a combined report.
দেখি একবার এক মিনিট এটা কি
না আরেকটা দাও
আরেকটা দেওয়া আছে তো আমি খুঁজে পেয়েছি দিন ওটা দিন না both the reports are similar একই তো এটা কোথায় গেল same report kindly
The report which has been filed in connection with
yes
16288 will be treated as a report on the in this matter.
my report is also there but somehow it has been misplaced
just now my lord it has been
কি বলছেন গো দেখো
the two reports are there my lord anyway your lordship kindly treats this report
how many reports you have filed?
Two reports my lord in respect of
কোথায় দিয়েছেন বলছি এখানে দেখতে বলুন
Milord, on the last, your lordship kindly sees your lordship's Milord order in the previous day, Milord, your lordship was pleased to observe, Milord, that the earlier report has been misplaced. Department is directed to trace out the report, but Milord, both the reports are same, identical.
But the department has made a endeavor to contact you, but it cannot be prepared.
So she contact করেছিল?
হ্যাঁ এই যে এইখানে সেটা অ্যানেক্স করে দিয়েছি
Milord, this has been annexed here in this report. Kindly treat this report, Milord.
আমার ফাইলটা চলে গেছে ওখানে নিয়ে আসুন
জটিলতা করিস না তোরা
কি বলছেন এখানে আমার অ্যানেক্স আছে বলছি
yes
দেখি এইটাতে কি বলছেন অ্যানেক্স আছে পেজ নাম্বার
Milord 5 annexure R1 report in respect of 21159
page 5
lordship Milord of my report Has your lordship got it, my lord?
Yes, sir. I
Yes.
got it. Thank you.
Same report, my lord. My lord, if your lordship kindly takes this writ petition, if your lordship would find land has been purchased in the year 2008, Act has been enacted in the year 2006, came into force, my lord, on and from November 2005,
Huh.
and thereafter he kept mum. He didn't raise any objection. In the year 2023, he filed this writ petition. Milord, cause of action, Milord, he is creating by giving a Milord representation in the year 2023. And Milord, if your lordship kindly takes my report,
And one judgment I will cite, my lord.
Definitely, I will see.
Milord, kindly have a look at my report, Milord, at page 9. Milord, I am taking the point of Milord
9.
delay. Yes, first. And second, Milord, kindly takes page 9. May I place the report, Milord?
Yes, sir.
Milord, at the bottom, Milord, paragraph 1. Has your lordship got it, Milord? In the year 1992, realizing the importance of this unique wetland complex, the Green Bench of the then Honorable High Court in its published judgment in the matter of such and such, Milord, the following directions was passed. There shall be an order of injunction restraining the state respondents from reclaiming any further wetland. There shall also be an order of injunction prohibiting the respondents from granting any permission to any person whatsoever for the purpose of changing the use of the land from agricultural to residential or commercial in the area as indicated in the map annexed to the petition and marked with the letter C. The state respondents are further directed to maintain the nature and character of the wetlands. To maintain the natural character of the wetlands in their present form and to stop all encroachments to the wetlands area as indicated in the map annexed to the petition marked with letter C. The state respondents are further directed to take steps as to stop private alienation and if required by extending the statutory provision in regard to. Because thereafter your lordship kindly sees in that point number 3, your lordship kindly, Milord, there is a Milord international Milord convention that is called Milord Ramsar Convention. India is a treaty to that signatory to that convention. Paragraph 2, it says in 2002, the Ramsar Convention recognized East Calcutta wetland as a model of a multiple use wetland due to the site resource recovery systems. The Ramsar Convention, which is India is a signatory, is an intergovernmental treaty on global environment that deals with wetland ecosystem across the world. The web page of the Ramsar Site Information Services depicting this site number such and such of East Kolkata wetlands along with the corresponding map of is annexed here. In the light of the above judgment of the Honorable High Court of Calcutta and after achieving the status of a Ramsar designated wetland complex of international importance, the government of West Bengal constituted a managing committee and managing committee has been constituted. Certain orders was passed and they have inspected the entire wetland. There is a resolution to that effect that has been taken. Your lordship kindly takes next page, page number 11, para 7, relevant, paragraph 7.
Yes.
On 31st March 2006, the government of West Bengal enacted a specific act, namely East Kolkata Wetlands Conservation and Management Act 2006. Along with it, Schedule 1, containing the list of full and part moujas, and Schedule 2, containing the same map as discussed. The area of East Kolkata wetland is defined in Section 2 of the East Kolkata Wetlands Act. According to the definition, East Kolkata wetlands means such of the area included in the list of Ramsar sites as are specified in Schedule 1 and shown in the map in Schedule 2 of the Act. The relevant pages are there. The DAG number which my learned friend is referring, subject land, that is 520, 520 and 550 or 664 of Mouja within the Mouja Collaboria and within the Schedule 2. It is to be noted that DAG number 520, 521, 550 or 670 of Mouja Collaboria, jail number 7, District South Chobbish Pargana are included in the full Mouja, namely Kulberia, which is depicted in Schedule 1. my lord, kindly comes to me, lord, that the same map has been included in the Ramsar Convention, that is at point number 9. Moreover, from the map with the Ramsar Convention, it transpired that the Mauja Kulbida is fully included within East Kolkata wetland. The map in the annexure of the communication of the such and such officer, it's 30th November, September 2000, shows the whole area of Mauja Kulberia, and the map in Schedule 1 of the EKWS 2006 contains Mauja Kulberia in its totality, entire totality. There are 4 types of land classification in the East Kolkata wetlands area, that are substantially water body oriented area, agriculture area, productive farming area, and urban rural settlement area. And the said Act 2006 is applicable on all aforesaid land classification, that is on the whole area as shown in the Schedule 1 and Schedule 2. The petitioner then purchased the land in the year 2008, whereas the state government enacted the act in the year 2006, which came into effect from 16 November 2005. According to Schedule 1 of the EKW Act, the land in question of the petitioner, Dock number 520, 521, 554, and 670 of Mauja Kulberia, jail numbers were under PS Kolkata such and such, which is fully within East Kolkata wetlands. As per the Act, the characters of the subject land are substantially water body oriented area and agricultural area. But however, it is to be noted that irrespective of land character, the EKW Act of 2006 is applicable on the whole area of EKW. Section 2D of the EKW Act states that land includes any wetland. As per Section 9 of the EKW Act, change or character of mode of use of land in EKW is subject to previous sanction of the authority, that is East Kolkata Wetlands Management Authority. Moreover, as per record of drive submitted by the petitioner, classification of the subject land is predominantly Shali, that is agricultural land. In accordance with the aforesaid judgment of Calcutta High Court, change of land character is prohibited from agricultural to residential or commercial purpose in this wetland. Because this is the next is verified according to Section 17 of the EKW Act, the authority has the power to include any area in or enlarge any area of East Kolkata wetlands, but does not have any power to exclude any area of this wetland complex. Thereafter, Millard, year 14 and 15, Millard, central government, Millard, framed certain rules in the, for preservation and conservation of the Millard wetland areas. So, Millard, Millard, in terms of Section 17, we cannot, Millard, exclude any area. And this is, Millard, land has been shown under this act, which has also been shown in the Ramsar project, Millard. So that is not permissible, Millard, in terms of the statutory provisions. My lord, knowing fully well,
yes,
land has come under the purview of the act. He has purchased this property. Kept mum, now he is challenging.
No, my lord, I have stated that I was not aware of the fact. Otherwise, my lord,
2008 to 2023,
No, my lord,
he kept mum.
What material is there? What materials are there to declare, give you relief?
my lord, what my learned friend, my lord, submitted before lordship, my lord, that there is
Take
no.
down.
No, my lord, I will cite one judgment, my lord.
Judge, so many judgment.
First of all, my lord, Section 10 of the Act is, my lord, very important, relevant.
Huh.
Because the Act itself, my lord, provided that the wetland can be, my lord, converted into agriculture and commercial. Lordship, can you have a look? And Section 11, my lord, before declaration of wetland, my lord, a method or by technology has to be, my lord, applied. That has not been done here, my lord. Only, my lord,
after declaration.
my lord, only in respect of, my lord, my land, that has been, my lord, declared as wetland, my lord, without any basis. And, my lord, this honorable court, my lord, can, my lord, exercise the power of judicial review if the policy of the government, my lord, unconstitutional and not in accordance with the law. Lordship, kindly have a look, my lord.
Given that is
My lord,
unconstitutional.
my lord, kindly have a look to Section 10 of that Act. Section 10 and Section 11 of the Act. Hello, what is my case? My case never possesses the character of my water body or wetland. Then, my lord, I put this question to myself: how, my lord, my land has been declared as wetland?
It was previously declared.
But that is, my lord, I am challenging. My lord, that is that this honorable court has got the power to exercise, my lord, judicial review. My lord, that judgment I will cite before lordship, my lord. That is, my lord. My lord, this judgment, my lord, it is reported in 2000. 22 volume 2 Supreme Court cases, the Honorable Supreme Court held, my lord, if, my lord, any government policy, my lord, does not in consonance with the, my lord, provisions of law, then, my lord, it has to be struck down.
Very good, sir.
My lord, kindly have a look, my lord, section 10 and 11 of the Act.
You have enclosed, no?
No, the Act.
In my Milord report, I have enclosed page 52. My learned friend is referring to clause 10, section 10, that is page 52.
No, what material is there to exclude your land from the wetland area? That I fail to understand.
My lord, that is, my lord, I was showing your lordship the classification of the land because of the.
Take down.
Sir, my lord, kindly have a look to this judgment, my lord.
So
Twenty-two, volume 2, SCC. No, it is regard to the government policy. Page 1. My lord, I am relying upon, my lord, paragraph 28, 32, 33.
just a minute. 2022, volume 2, SCC 1. Para?
Para, my lord, 28, 32, 33.
Yes. It is really a legitimate expectation, doctrine of legitimate expectation. Doctrine of legitimate expectation, so far my knowledge goes, has got no manner of application when a public policy is involved. Freedom to change the policy in the park cannot be fettered by application. That has been stated.
But if it, my lord, if it
Eh,
shocks
হবে না।
the,
applicable, it is
my lord,
not
Hey, take down.
shocks the,
Oh,
my lord,
হয়ে
it
গেছে।
shocks the conscience of the court, my lord.
The writ petitioner and
Other one same similar matter,
Huh?
similar.
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 Acha, with the
Sir, I
dis
have relied upon my lord the section
Like
K
some
because there is a matter provision for conversion.
very good, sir. With the since এটা লিখে রাখুন since
Next আমার সঙ্গে কল্পিতা পাল।
Next, ছয়েরটা কল্পিত পাল।
ছয়টা।
ছয়েরটা
Item number 8, my lord.
I guess, my lord, I am mentioning this matter.
not the mentioning our. Yes.
No, no, item number 8, my lord. The similar order your lordship has passed in the month of July. Same order has been passed in the same petition, similar petition, my lord. So I think
Dispute. Matter was dismissed for default lordship, so I am playing on only inclusion for restoration application lordship.
Sir, what is your predicament? What is the predicament in coming before before this court on Monday?
I know, lordship in the morning.
No. Sorry. Come on Monday at the mentioning hour, I shall definitely consider.
পরে কি ধরবে না আজ আর ধরবে না?
now to
Have you served notice?
Sir, notice.
You know, they can have a determination to take it.
Effective of classification.
Yes, yes, yes. It is up to 2015.
No, 23 now.
Then it is not.
23 now.
Read petition irrespective of classification up to 2015. If it is a land matter, then it is all right. 23.
Yes, it relates to land minor.
Group
But-
one.
Group one.
Group one.
Yes.
ঠিক আছে, it's all right. Call the list.
I am for the petitioner, my lord.
Mr. Basu Malik is appearing for this state, my lord.
Who is appearing?
Mr. Basu Malik.
Very short issue. I am the.
Where is he?
He went to courtroom number 11, my lord. I informed him.
Ask over for some time. Ask him to come.
কতক্ষণ লাগবে?
First matter আছে ওখানে।
ফার্স্ট কল করেনি।
I am the receiver in this matter, my lord. This is old suit, my lord. Scheme has already been framed, my lord. Actually, no need for hearing because the parties have settled and it is the trust property, my lord. It is popularly known as Aryadaho part body matter, my lord. I am being the receiver, my lord, submitting. No need for hearing. Only on the basis of the schemes, the receiver will act, my lord.
File take badi. Oh, file is not here. File is not here.
So, my lord, for the time being,
Will again listed.
let the matter be out of list. Because my lord, no need to.
Very good. তাহলে একটা অর্ডার করতে হবে না। উইদাউট পেপার ছাড়া অর্ডারও করা যাবে না।
Yes, my lord, without file.
এটা আপাতত লিস্ট করার দরকার। ডোন্ট লিস্ট ইট। আরে কিসে অর্ডার করবো ফাইলটা না থাকলে? এটা তো রেকর্ডে অর্ডার করতে হবে। কি হলো? আচ্ছা কি হলো?
My lord.
You are in item number 1?
Yes, ma'am.
Very good. Let us take item number 1.
What is that? Instructionটা দে। কোন সময় মামলার সময় তোরা থাকিস না কেউ।
My lord, in this matter, petitioner is the landlord.
ব্যস্ত কি?
The tenant depositing rent since 2014 and all rent.
It is a new motion.
New motion.
Under the West Bengal Premises Act.
No, actually, it is under group, not West Bengal premises. There is recovery of remittance of the deposited rent from the rent controller.
Then why it is before me?
Because that is completely the land matter under group 1, the secretary and rent controller is not under any case against not any order. I have not challenged any order.
It is under group 1.
It is under group 1, land matter. Because the point is this, that rent deposited with the rent controller by the tenant. I am the petitioner is the landlord.
Give me a second. Yes, sir.
Tenant deposited rent and I have enclosed entire 131 challan that is deposited in the rent controller. I am asking for remittance the amount. I am the landlord. I am entitled to get that amount.
Natural.
But they are not disbursing. That is the point.
My lord, lordship knows, my lord, there is a prescribed pro forma for the purpose of getting that money. So they have to apply under by that pro forma. What they did is, my lord, they have made merely a representation before the authority concerned.
No, you have to file the challan.
Yes.
You have to file the challan.
My lord, if lordship takes my, I have
deposits have been lapsed or not lapsed deposits.
No, that is depositing intact.
In the rent control.
In the rent control.
So in the meantime, that those have been lapsed.
No, there is no provision for lapsing.
No lapse is there.
No, this
is kindly go through this once, my lord. This is report I have sought for from them, my lord, the authority. দাঁড়াও দিচ্ছি দাঁড়া এক মিনিট দাঁড়াও স্যার দেখুক আগে।
Before filing the writ petition, we have approached, this would have given the advice that there is a challan prescribed format.
নট চালান দি অ্যাপ্লিকেশন দিচ্ছি দাঁড়াও নাই দেখা যায় যাক 2 হোক যাক 40 কত হচ্ছে 16 10 কত হচ্ছে First page is Millard, page 2 is
Give him a
Millard-
copy, give him a copy.
A copy. Page 2, Millard, that is the letter of them which has been annexed with this writ petition. Now the next page is, my lord, to the Deputy Secretary Rent Controller, Millard, that is at page 3, Millard. It has been mentioned, Millard, in reference to the letter caption above intimated, the learned advocate on behalf of Ajoy Raj Agencies Private Limited has applied for payment of rent amounting rupees so and so. The following procedure, see enclosure, is being followed in this office for disposal of each and every application for payment as per section 11 of the West Bengal Premises Tenancy Act 1999. But the application has not submitted any such document for the processing of this case. Instead, the petitioner has filed the case number so and so before the Honorable High Court at Calcutta against the state. This office has moved to the learned advocate on record of the West Bengal so and so for appointment of so and so, so and so, so and so. This is the number 1, my lord. Then, my lord, is, my lord, page 4, my lord, that is the steps which he has to take for the purpose of getting this money, my lord. First, applicant has to apply for the searching section for the relevant month's deposit. Step 2, it has been, my lord, gradually mentioned.
Come to page number 6.
Lordship.
Second paragraph. Page number 6, second paragraph.
Yes, my lord.
Statement of
Second paragraph. Statement of lapse deposit of the, yes, ma'am. That
that
has
I
to-
said.
Yes, ma'am.
Yes, take
So
down.
that has to be calculated by the authority concerned itself, ma'am.
The writ petitioner and the respondent state and its functionary are represented by their respective councils. Stop paragraph. Paragraph number হয় আমারটা প্রত্যেকটায়. By filing the instant writ petition, the writ petitioner has prayed for issuance of appropriate writs against the respondent number 2 authority for commanding him to remit the deposited amount of rupees 11,13,500.
Lord, one point I want to mention, my lord. They have page number 4, they are referring to. That is actually.
Sir, listen. You will listen to my order, you will get.
No, my lord, one second. Otherwise, it will be some difficulty. This is whether this is from the any statutory provision or is there, unofficial.
Absolutely
and
statutory
unofficial
provision.
instruction.
As per the procedure, as per the rules, sir. লিখুন কি লিখলাম? Together with interest, as has been deposited by the tenant of the present writ petitioner. Stop there. At the time of hearing, Mr. Basu Mollik, learned advocate appearing on behalf of the respondent state, has submitted a memo dated 10/7/2025 as prepared by the respondent number 2 hearing. Stop. Let this said memo dated 10/7/2025 is taken on record. এইটাকে না সেকেন্ড প্যারাগ্রাফ করুন, তারপরটাকে আগেরটাকে থার্ড প্যারাগ্রাফ করুন। এই যেটা এখন বললাম এইটাকে সেকেন্ড প্যারাগ্রাফ করুন, যেটা এইটা করলেন আর এটা সেকেন্ড। Yes. Stop. At the time of hearing, what's your good name, sir?
Tapos Dotto.
Mr. Bosdotto, learned advocate appearing on behalf of the writ petitioner, draws attention of this court to the various challans to the various challans as have been annexed to the instant writ petitions. Stop. It is submitted by Mr. Bosdotto that from the said challans it would
Tapos
reveal.
Dotto, Miller Tapos Dotto.
Oh, Mr.
Tapos Dotto.
দত্ত কোনটা? হ্যাঁ, তাপস দত্ত, আমি শুনতে ভুল করেছি। It is submitted by Mr. Dotto that from the said challans it would reveal that on and from March 2014 till
January 2025,
till January 2025
131 Chalan.
Rent was deposited by the tenant of the writ petitioner in the office of the rent control, in the office of the respondent number 2 authority code, to the credit of the rent petitioner, being the landlord. Stop. It is submitted that despite submission of representation, the respondent number 2 authority has failed and neglected to disburse the said deposited amount of rent to the writ petitioner. Stop. Per contra, Mr. Basu Mollik, learned advocate appearing on behalf of the respondent state and its respondents, draws attention of this court to the reports as filed today. Stop. It is submitted by Mr. Basu Mollik that from the report it would reveal that it has been categorically indicated by the respondent number 2 authority that in order to get the deposited rent in his account, the writ petitioner has to comply with certain Call from item number 2, except item number 3. Item number 3 is over.
Item number 2 also. Messrs. Edwin Private Limited. Item number 4, Calcutta Chemicals Industries. First call, item number 5, State Bank of India. Item number 6, Punjab National Bank. Item number 7, BD Electrical Industries. Item number 8, Messrs. Bhandari Sales. Item number 9, Bank of India. Item number 10, Bank of Baroda. Second call.
From 2. Ashwin. Wait. The parties are not represented. The parties are not represented. Stop para. In view of the absence of the plaintiff, CS such and such is dismissed for default. Interim order, if there be, stands here. Go on calling.
Item number 4, Calcutta Chemicals Industries.
Same order. Dismissed for default. 5. No. Yes. 4 show করেছেন? Show করেছেন কিনা বোর্ডে show করছে না তো? Yes. 4 same order. 5.
State Bank of India.
Same order.
Item number 6, Punjab National Bank.
Same order.
Item number 7, BD Electrical Industries Private Limited.
Same order. Yes.
Item number 8, Messrs. Bhandari Sales.
Same order.
Item number 9, Bank of India.
Same order. 10.
Item number 10,
Same
Bank
order.
of Baroda.
Yes. Next. 11.
Item number 11, Lease.
Lordship, I'm for the petitioner. I'm praying for accommodation on
Why?
senior counsel Orindam Banerjee is leading in this matter.
Sorry?
Senior advocate Orindam Banerjee is leading in this matter. He has
On this ground, every day you are seeking accommodation. So let the matter go out of list. On behalf of the writ petitioner, an accommodation has been paid for. On behalf of the writ petitioner, an accommodation has been paid for.
I beg to appear on behalf of the state.
But I appear for KMDA because
KMDA?
I was appearing for.
Oh. Who is the answering responsible? KMDA?
Both. But principally state.
Achha.
This acquisition proceeding,
The acquisition
principally they
proceeding,
have to.
possession has been handed over to the KMDA and subsequent action of the KMDA has been challenged in this petition.
No, my lord, entire acquisition has been challenged in the writ.
No. There is no prayer for such.
Filing. Order book দিয়ে কি হবে? Two 2008.
Yes.
This has been heard of before various courts. Several orders will be there.
But because of intervening applications one after the other by some of interveners, my lord, the hearing
And applied for the addition also.
that has been rejected.
Rejected.
GA9 টা rejected. But prayer D is not my challenge to the acquisition.
Yes.
Now, my lord. Now, my lord, what happened, my lord? May I just briefly narrate the facts of the case, then I take your lordship to the documents one after the other. Now, the petitioner, my lord, being the riot of 3 plots of land, my lord, kindly notes these 3 dark numbers.
Give me a second, sir.
Your lordship may kindly excuse me for some time. He'll take some time.
আমি আছি তো আমি আছি তো
Yes, sir.
The petitioner being the riot of 3 plots of land. My lord, kindly notes the 3 dark. My lord, I'm concerned with these 3 darks. Dark number 3777, 3775, and 3788.
3775 and
3788.
I repeat 3777.
Yes, my lord.
3775.
Yes, my lord.
3788.
Yes, ma'am.
Those are
Now,
plot numbers.
These are the plot numbers.
LR.
Look, these are RS dark numbers.
RS plot.
RCS and RS.
RS plot numbers.
Yes. Now, my lord, reference to this, my lord will find that I am the recorded riot. My lord kindly turns first, my lord, to page 20A of the writ petition.
Page number 20A. Capital A.
Capital A.
Yes, page number 20, capital A.
But my lord will find in the lower portion, my lord, Profullo Kumari Dotto, the petitioner Rayati Sthitiban. My lord has found on the
Profullo Kumari Dotto,
Nibaran
Nibarananda
Chandra Dotto.
Dotto, Raya Dinendra Street, Rayati Sthitiban.
Yes.
Right.
Similarly, with respect to the other 3 plot, and my lord turns over, my lord will find the dark number at the next page, 3777.
Yes.
Now, my lord, kindly turns over to 21A. Same thing, my lord, just indicating with respect to the other 2 plots. Same thing. Sthitiban right with respect to the other dark number, my lord. This is the 21 is 3788. And my lord 22A, my lord again.
It is 3777, 377.
3775 and 22A, my lord is 3788. Page number 22 reflects 3788. So, my lord, these are the in this recording, my lord, I being this Sthitibat right, my lord, today I challenge, my lord, the acquisition, my lord, claim to be made by the state, my lord, is absolutely bad in law. So, my lord, why I say this, my lord, the acquisition by the state as alleged, my lord, is bad in law. My lord, kindly turns, my lord, to the writ petition for once. My lord, this is important. Kindly keeps a note of it. I will argue on this point later. My lord, paragraph 9 kindly notes of, my lord, what happened, my lord. Suddenly,
You are the successor in interest of Profullo Kumari.
Yes.
Supriya Datta.
Supriya Datta. My mother is Prafulla Kumar. Huh? Grandmother. Grand. Now, my lord, paragraph 9 of the writ petition, my lord, kindly takes note of for the moment. I will argue on this point later on.
Yes.
Now, my lord, what happened on those plot of land, my lord, a signboard was put in, my lord, by the KMDA saying that the plot has been given to Messrs. Holdiram Limited.
Will you kindly place, Mr. Chatterjee?
Your petitioner respectfully states and submits that the property in question never vested either in the government or in KMDA, and consequently KMDA never acquired any right to grant any lease in respect thereof to said Messrs. Haldiram Limited. Your petitioner has recently come to know that a signboard that was put up by KMDA in which it claimed that Messrs. Haldiram Limited was in possession or occupation thereof has been pulled down. Your petitioner submits that there has been no acquisition proceeding taking away your petitioner's right in respect of the said land.
So where from the Holdiram comes?
Yes, my lord, that's why I say I will argue, my lord, this would be my lord, an alternative
The signboard
argument.
that was put up by which it claimed that Mr. Holdiram was in possession or occupation thereof has been pulled down.
And my lord,
If there is no acquisition proceeding taking away, never acquired any. Very good. Then
and now, and my lord, KMD has also entered into an agreement with Messrs. Holdiram. My lord, I have annexed that document in my reply to their opposition. Now, my lord, kindly.
The property is situated in which place?
This is Koshba. Ruby bypass connector, my lord, on that area.
Then how the original side jurisdiction has been invoked?
My lord, that is a preliminary point. My lord, this was negated, my lord, by the earlier bench Justice Chaudhary. This point was raised. My lord, this was raised because under CPC, my lord, when you participate in a proceeding at the stage of hearing, now at that stage you cannot raise this point, my lord. This would be an original side or appellate side. You are subjected. This point was never taken up. Affidavits were.
Original side rules is abundantly clear to an extent this point is concerned. If
this point has been negated, he cannot re-agitate a point which has been negated.
Very good.
Now, my lord, kindly turns to, my lord, page 27 of the writ petition. My lord, here dates would be very important, my lord. This letter is written by the Calcutta Metropolitan Department Executive Engineer. Now, in this letter is issued on, my lord, 9th of September 1996. My lord, date is very important. My lord, what it says, enclosed please find one copy of the site plan showing the plot pertinent to pre-July 96 structure of Srimati Prafulla Kumari Datta under Mouja Koshba, Dag number such and such at sector ABC under East Calcutta Area Development Project. The name of Srimati Prafulla Kumari Datta appears in the list of pre-July 1978 structure owners within East Calcutta Area Development Project prepared by CMDA and legal non-official members of East Calcutta Advisory Committee. The plot has been demarcated in consistent with the approved layout plan for East Cell. Project clearance for exemption may be furnished after due verification of original deed and other related documents in respect of the structure from your end. So, my lord, clearance from my end is being sought by the, my lord, CMDA in the year 1996. Now, my lord, what happened, my lord? Now, my lord, kindly turns to page 28.
Demarcation of land. Site plans showing the plot on pertinent to the structure. This is of the year 1996. Very good. Then what happened?
Then, my lord, kindly turns to page 28. This is letter dated 1999. Here, my lord, the Calcutta Metropolitan Development Authority writes, I am directed to refer to your letter number such and such on the subject mentioned above and to inform you that all the plots of land in Mouja Koshba JL number 13 have been decided to be brought under preliminary notification under section 4 of the Land Acquisition Act 1894 to 16/5/1995 for years. So therefore, as on 1999, the CMDA says it has decided to bring, not yet acquired. So a decision is in process.
So it is this letter has been issued prior to the publication of the declaration.
Yes.
That is to say,
That is to be in
Section 4 says about the declaration.
Yes.
Am I correct?
Absolutely.
So a decision to be brought under preliminary notification under Section 4.
Section 4.
So it says that according to you, that Section 4 declaration notification is going to be published.
Going to be published.
That says.
Absolutely, my lord. Then, my lord, kindly, my lord, this is an information obtained.
Give me a second, sir.
No, no, information is important.
Yes.
Now, my lord, an information has been obtained by us. My lord, kindly takes up page 29. The original copy is just the next page 29A. A typed copy is 29.
Previous one is 28.
28.
Page number 20 is the date কত ছিল? Page number 20 or it was 1629, no?
Yes. Now, my lord, Department of LA Collector, Land Department, my lord, we put an information, my lord, to inform us whether these three plots, 3777, 3788, 3775 has been at all acquired. My lord, the answer to the query was from the department. It appears from the available record. My lord has got page 29. It appears from the available records of this office that CS DAC number 3775, 3776, 3777 and 3788 of jail number such and such, ward number such of Mouja Koshwa have not been affected by any LA proceeding of this office from 1980 to 16/5/1995. So, my lord, it's their department who has no information about this acquisition. Rather says, my lord, there has been no LA proceeding.
Very good. Then,
My lord, similarly, my lord, once again we, my lord, got an information at page 30. Same information was supplied, but the period was further extended to 2001. Till 2001, there has been no LA proceeding. Kindly turns to page 30.
3227, 3775, and 3788. Yes. Page number
30. 30. Now, my lord,
it is dated.
my lord, this information is dated
18 to 2001.
Yes. My lord, 12th September, there is a stamping. My lord, I find in page 29A. 12th September 2000, in 2001. My lord, this has been given. My lord, we'll find at the bottom.
No, 30 is corresponding to 31A. 30A.
Yes, sorry. 30 is corresponding to 30A. Yes, 2001. February 2001. 16.
16 or 18, something like that. Next.
Now, my lord, kindly turns to 31A, the original copy. My lord, a circular, or may I say, my lord, a notification and an order, my lord, from the land department was issued, where, my lord, has got page 31A, my lord, where the nomenclature at the top, my lord, may I just read first. Survey plot in fully cancellation to order of requisition under section 3(1) of the West Bengal Act of 1948. What it says?
Survey plot in fully cancellation of
Cancellation to order of requisition.
under Act 2 of 1948.
Yes. The undersigned is pleased to fully cancel so much of the Lord mistake order of requisition dated 73-74 under section 3(1) of the West Bengal Land Reforms Act 1948, which was served upon the interested persons between 2nd of May 1978 to 10th of May 1979 to 14th May 1979 to 15th March 1979 to the periods relating to the plot numbers noted below for East Calcutta that project. Schedule of lands. Jail number 13, Kosba Mauja, sheet number such and such.
Straight away come to the RS plot.
Yes, RS Dags number. These three plots sought to be cancelled.
No, to the extent of those 18 kata, 7 chitak, 29 square feet.
Cancelled
and
area in 18 kata, 7 chitak, 20 square feet. Yes, 29 kata, 70 kata.
29 kata.
Yes.
So that portion was cancelled.
So cancelled. It was indicated in this.
According to you, are the owners of how many, how much quantity of land in those plots?
Entire.
Huh?
Kindly sees acre and acres 0.31. This all 0.31, 0.48, 1.717. I'm entirely owner of this. It's 118 katas approximately.
RS Dag number hectare or
775.
hectare oblique hectare cancelled in area in Khotian.
This is the area in Khotian, in kathas, this is 18, but in acre or hectare, 0.31.
No. That is not very clear.
31 decimal. And hectare holo 0.1254.
That is the area of the land.
This 0.31 is the total area.
No.
Total area
area is 118 katas.
No, it should do 3775.
3775 is 31 decimal.
Total. The total is 0.31 decimal.
Out of 31 decimal, 18 kata was cancelled.
Cancelled. Yes. Similarly, in other plots, it was also indicated that those are cancelled to that extent.
Okay.
Yeah. Oh, actually, stick it. And my lord will corresponding to the RS Dags, it tallies with the areas. But there is no dispute to this area concerned. The RS porches which has been shown previously, my lord will find the total area with respect to plot number 3775 is 0.31 decimals.
दागेर मूड जाएगा কোথায় পাবো বাবা
Page 22 31 decimals my lord will find after 21A the next page.
21A.
After 21A the next page. My lord will find with respect to plot number 3775 31 decimals.
3775. Wherefore we'll get the জায়গার মোট পরিমাণ
31 মিলট acre blank শতক decimals.
ওটা তো স্টিচ হয়ে গেছে দেখবো কি করে রে বাবা হ্যাঁ 31 decimal is there.
31 decimal is there.
31, 48
and Milord
1.17. 1.17 এখানে কি বলছে দেখি তো
Milord it tallies.
So entire land has been
de-requisition. Now, Milord, after this, Milord, what they say is, Milord, Now they say, my lord, we have issued a notification under section 4 of the act. Under
Which
Act
act?
2.
Act 2.
Yes. Now, my lord, kindly takes their opposition first, then I will take my reply to that. Stated. দেখো জিয়াউল হক
জিয়াউল হক
একটা নোটিফিকেশন আছে নোটিফিকেশন দিয়েছে Maharaj got the opposition, my lord. Now, firstly comes to, my lord, their paragraph 6 of the opposition. Paragraph 6B. Or A, my lord, from A onwards, my lord, may I just please. The writ petition is praised to withdraw, rescind, or set aside entire dealing, including the license deed made between KMD and Haldiram, as well as further praise for declaration there has been no acquisition proceeding in the respective DAG number such and such.
Yes.
RS plot number such and such, along with several other plots under Mouja, Koshba, jail number 13, were acquisition by the competent authority, wide LA case number such and such of 7374. Milord kindly reconciles the date. Milord 99 they say they will bring, they have decided to bring. Issued by Milord the KMDA. KMDA is communicating to me. Milord, they say in 7374 they have initiated an acquisition proceeding under Act 2 for the purpose of construction of EM bypass by the requiring body of KMDA. For such acquisition, the requiring body, being the CMDA, now KMDA, was handed over the entire area, including the present plots of land on 18/12/1973. Now, my lord, I pause here for a moment. Now, my lord, they say, my lord, it has been acquired under a certain LA proceeding and it has been given to KMDA, and KMDA is now in possession, my lord, of 1973. Then, my lord, first question I put to myself, my lord, how can KMDA in 1999 say that we decide to bring it under, my lord, acquisition? Firstly, this cannot be done absolutely contrary stand.
But Mr.
Secondly,
Chatterjee,
yes, my lord, I come
Mr. Chatterjee, it may be so that those letters have been issued
Yes,
without
my lord, I know.
consulting the record.
I know, my lord, maybe. My lord, I absolutely thinking that too in my mind. I say, my lord, this is under Act 2, there is no dispute. Now, my lord, what is Act 2? My lord, kindly takes the Land Acquisition Act. Firstly, my lord, goes through the document and then relate to, my lord, Act 2, my lord, whether acquisition at all has been done or not. Kindly takes up page 12 of the opposition. Notification to
Yes.
My lord, this is a certificate of possession issued by the Land Assistant Land Officer CMD. Certified that I have this day at such and such received possession of the property at hands of Sri such and such, or more or less such and such, comprising cadastral Alipur numbers. My lord, I don't know when there is RS plot numbers at that point of time, why cadastral is being used. Shown such and such, Moja Koshba, jail number such and such, collector sub which has been taken possession by collector 24 paraganas in exercise of power conferred by subsection I of section 3 of the West Bengal land requisition such and such as amended by such and such. Well, there is no reference to any DAG number. Milord, then entire jail number is traceable to the jamindars.
next page
দাঁড়াও যাচ্ছি তোমার পজিশনটাকে দেখেন
হ্যাঁ পজিশনের নেক্সট পেজে প্লট নাম্বার গুলো দেওয়া আছে
Now, Milord, there is no reference to the possession of these DAGs.
Yes, next page টা
আরে
next page টা দেখেন না তুমি বলছো যে
Now,
submission করছো
vacant possession delivered. Milord, details of land. Milord, আমি page 13.
Mr. Mahatha, please allow Mr. Chatterjee to make submission.
Milord,
He's
kindly
holding
see-
brief of his client.
Yes. Milord, kindly sees the Moja plots. Milord, there are as number as Milord many plots. Among these 3 plots are also mentioned.
Three triple seven is there.
Yes.
3775 is also there. And 3788. It is at the last. Yes.
Now, Milord, from this letter, Milord, therefore, Milord, firstly, the LA collector has taken possession under section 3(1). It is their stand. Then, Milord, KMDA takes possession from the department.
No, first 3-1.
Yes.
Thereafter 4. Vesting complete. Thereafter possession.
Yes.
No, my lord.
Huh?
In Act 2, my lord, the section 3(1) possession. Thereafter, my lord, the
Under section
No, no, no.
Act
3-1,
2.
3-1 is the requisition and possession.
Requisition and possession.
Right, sir. Thank you. And
Great.
4 is vesting complete. And thereafter, it will be handed over to the requiring body.
Grateful, Milord. Milord, from this letter, Milord, I say, Milord, section 3(1) has not been complied. This is not section 3(1).
No, this is not a notification.
Absolutely. Milord, kindly let them show, Milord, till date, there is no document furnished by them showing that 3(1) has been complied. Milord, kindly takes 3(1), Milord, for my satisfaction. What is 3(1) and how it is to be promulgated? Milord, kindly sees.
I'm already there, sir. Before you.
Yes. Milord, may I just place 3(1)?
Give me a second, sir. Let me note one thing. Yes, Mr. Chatterjee. 3-1.
3. Power to requisition. If the state government is of the opinion that it is necessary so to do for maintaining supplies and services essential to the life of the community or for increasing employment opportunities for the people by establishing commercial estates and industrial estates in different areas, or for providing proper facilities for transport, communication, irrigation, drainage, or for creation of better living conditions in rural and urban areas, not being in industrial or other areas excluded by the state government by a notification in this behalf by the construction or reconstruction of dwelling places in such areas, or for purpose connected where with or incidental thereto, the state government may by order in writing requisition any land and make such further orders as it appears to be necessary or expedient in connection with the requisitioning, provided that no land used for the purpose of religious worship or used by educational charitable institutions shall be requisitioned under this section. 1A, a collector of a district, additional district magistrate, or the first land acquisition collector, Calcutta, when authorized by the state government in this behalf, may exercise within its jurisdiction powers conferred by subsection 1. 2 is very important. An order under subsection 1 shall be served in the prescribed manner on the owner of the land, and where the order relates to the land in occupation of an occupier not being the owner of the land, also on such occupier. If any person fails to comply with an order made under subsection 1, the collector or any person authorized by him writing in this behalf shall execute the order in such manner as he considers expedient and may, my lord, such and such. So, my lord, there has to be an order under section 3(1). Page 12 is not an order. My lord, if the rules are to be looked into, my lord, or my lord, the forms. Yes. Draconian Act. But, my lord, for the very reason it's a Draconian Act, my lord, the rules have to be followed in toto. There cannot be a single deviation from that. This is a settled law.
What rules you want to refer?
Now, my lord, kindly
The land acquisition rules is there.
No, my lord, I'm sorry, my lord, the form which I wanted to show.
Say like that. I am.
My lord, kindly takes up, my lord, if my lord's book would tally, form 1.
Form 1 is not here.
Form 1 is not there. But this is a form of order. But if my lord just have a glance.
দেখি দাও বইটা। Rules is there also. West Bengal Land Requisition Acquisition Act 1949.
So, my lord, the form 1 is the order of, my lord, which is required to be passed. My lord, under rule section 3, subsection 1. For acquisitioning, my lord, under subsection 4, section 4.
Yes.
Now, my lord, kindly takes up page 14 of their, my lord, opposition for once.
Page?
Page 14. Found, my lord. Now, my lord, October 17, 1974 is the date, extraordinary gazette publication, my lord, where, my lord, they issue a notice under section 4 for public purpose, my lord, if I may read the notice. Whereas such and such more or less of land situated in or near the village of Koshba described below have been requisitioned under subsection 1 of section 3 of the West Bengal Land Requisition and Acquisition Act 1948 by the person authorized under section 31A of the Act for the public purpose for providing facilities for transport and communications, namely for the construction of Eastern Metropolitan Bypass. Now, therefore, notice is hereby given. So, my lord, they say, my lord, under 3.1, the necessary compliance has been made. Now, hereby they give 4. So, my lord, I put this question to myself.
For making the vesting complete.
Complete. So, my lord, I put this question to myself. From any of the oppositions by KMDA state, my lord, let them show they have complied 3.1.
So you are saying that that has not been complied, with.
This is the only document they have annexed, my lord, today. My lord, when my writ petition is of 2008 and today we are in 2025, they come up with an opposition annexing page 12 that a possession has been taken over by KMDA to that extent. Where is the compliance of 3.1 or 3.1.12? Where is that order of requisition? There is a form of order, and that only order will not do. It has to be served. Where is the service?
So it was of the year 74.
74.
And you have challenged in the year
2008. 2008.
So what are you doing at that time?
If acquisition is bad, it's bad for all days to come.
How the court will presume that acquisition bad? Section 4 notification presupposes a notice or notification under
That is not correct. Section 4 doesn't presupposes 3.1. 3.1 is a separate order. Then today everybody will publish in Gazette publication and say I have done 3.1.
No, sir, it is not the publication on the part of any Tom, Dick and Harry. It is publication by the government.
But I say they are not Tom, Dick and Harry. Let them show that they are not Tom, Dick and Harry. When their department says it's not, these 3 plots of lands are not within the LA proceeding. Kindly takes up the annexures provided.
It has been done in the year 74.
Yes.
And you are challenging the 2008.
Yes. Because that's why I say paragraph 9.
What are you doing during this time?
In 2003, for the first time, this Holdiram comes and puts a board. My lord, I then
So what material is there that there was no acquisition?
My lord, the RTI information before coming to read court, my lord, I obtained those. My lord, I have completely shown to my lord. The land department is saying these 3 plots are, my lord, beyond the LA proceeding. The department issues notification that de-requisitioning or cancelling the requisitioning. What is answer to that? Answer to that is, my lord, a certificate that possession, not 3-1 order. If they say it's a contrary, that they have to produce materials before the court, the information supplied under the right to information is bad.
Page number 31 is issued on which date?
Page number 31.
I'm sorry, your cancellation?
Yes. 31.
2/1/2001.
1. I'm not just, my lord, making my submission in air. My lord, there are documents before the court.
Give me a second, sir.
31 is of 2001 issued, and
It is of 74.
yes.
So if vesting is complete, then how can it be this document?
So vesting has not been done. That's why the department has no records. My lord, they are proceeding as if, my lord, vesting has been done. That's why in 1999, my lord, kindly sees the KMDA rights. If KMDA is in possession, KMDA rights. It is being decided.
No, if I come to page number 31 of your writ petition,
Lord,
that is a cancellation in order of requisition under section 3(1). What does it say? The undersigned will cancel the mistake of requisition dated 73/74. Is it matching?
yes. Same LA2, 40F, 41 by F, 73/74. Same thing.
LA2?
My lord, kindly takes the averment in their opposition. It's matching. It's the same LA proceeding. My lord, paragraph 6B, page internal page 5 of the opposition.
Give me a second. I'll hear you. Please to cancel so much of the mistake order of requisition dated 73/31, which was served upon the interested person had to. LA case number?
40F.
Where will get that?
My lord, kindly takes paragraph 6B, my lord, there's own averment.
6B of the
opposition.
LA2 40F.
It's the same proceeding.
But in page number 31, that LA case number is not there.
Yes, my lord, on the top, LA2 case number 40F of 73/74. Just before, my lord.
Yes.
গেজেট का 40F গেজেট তো দিতে হয় না।
No, Mr. Chatterjee, then what is your stand?
No, my lord, there
Section 3 not published or section 3 published, but by
Section 3 has not been
this
done.
page number 31, it has been cancelled.
Section 31 has not been done, and my lord, acquisition, my lord, is bad in law, and my lord, kindly takes up my now, my lord, reply. My lord, that would reply to the states.
No, Mr. Chatterjee.
Yes, my lord.
Try to understand my question, what I am on. If you say that page number 14, come to page number 14 of the in opposition, that is a notification under section 4 regarding declaration.
Yes.
Vesting complete.
Yes.
You say there was no section 3 compliance.
No section 3 compliance.
Am I correct?
Yes.
Then you cannot rely upon say page number 31 of your writ petition.
No, my lord, subject to correction, my lord.
Page number, kindly come to page number 31.
31, yes.
If you say that there is no section 3 requisition, then you cannot rely upon page number 31.
That's why I say, my lord, I correlate. Why I say, my lord, I rely upon this also and my lord this also, saying that, my lord,
No,
kindly
no,
take,
sir. If it be,
kindly
you have to stick to one point. If you say that there is no section 3 compliance, for the sake of argument, I will accept there cannot be section 4. Am I correct, Mr. Chatterjee?
my lord,
But if you say that
because my lord is
subsequent, please listen to me. But if you say, I will allow you to make your submission.
Yes, yes.
But if you say that section 3, this is a document regarding cancellation of acquisition of section 3,
Yes.
then I will not allow you to content the previous submission. Because you
Because, my
rely upon this.
Because cancellation of order, my lord says. For that reason, there is a noting of cancellation of order of requisition.
Cancellation of order of requisition.
For that reason, my lord is saying
Absolutely,
that
of course.
these two cannot go together.
Absolutely.
But I understand what is falling from my lord. Kindly, but I answer my lord's query, my lord, first. Kindly takes, my lord, my reply to the opposition to KMDA.
Give me a second. Let me note once.
দেখো এই আমার reply to KMDA. Why Habishojit Mitra? Well, why this order of cancellation?
Give me a second, sir. Yes.
Now, my lord, kindly takes up page 59 of that reply.
Reply to what?
To KMDA's opposition.
Every innovation by the this is the opposition of KMD.
No, my lord, my reply to the opposition of KMD.
No, no, who is the respondent number 7?
7.
No.
Collector and district, my lord, land.
Who is the respondent number 7, Mr. Chatterjee?
My lord, collector and district magistrate of land.
এটা হচ্ছে AO of state. Jiaul Haq
Jiaul Haq.
for the state.
For the state. My lord.
তাহলে এটা হচ্ছে AO of state. Yes, কি দিয়েছে দাও?
My lord, in
It is
1990,
a affidavit reply against the
KMDA's opposition. But problem in these cases is, my lord, tell your lordship, my lord, we as petitioners has to search out documents because state would never come up fair. My lord, that's why, my lord, in opposition some documents are there, in other occupations because we are searching documents.
I am coming. সব fraudulent document কিভাবে দিয়েছো তুমি পিটিশনে আমি সব বের করে দিচ্ছি।
Yes.
Now, my lord, this is a notification issued by the Department of Land Reforms and Acquisition.
Page number?
59.
Yes.
My lord, I am reading the relevant paragraph from 2 onwards. The Land Acquisition West Bengal Amendment Act 1997 having been assented to by the President of India was published in Calcutta Gazette such and such under notification bearing number such and such of the Law Department. All requiring departments are requested to intimate as within 30th June 1997 if they are still interested in acquisition of land which is in possession has been taken under 3(1) of Act 2 1948 and no construction has been made upon such land. In case where replies would not be received, possession of land under 3(1) of the West Bengal Land Acquisition Act 2 of 1948 shall be deemed to have been inoperative and the possession of land would be restored in favor of ex-owners without any formal order of de-requisition. But the requiring authorities have to pay requisition compensation to the market value of the land on and from the date of taking over possession of the land prior to the date of restoration. With the request to prepare a list.
It is because of the fact that the lifetime of the act was limited.
Yes. Now,
Act 2 of 1948 was limited, which is why it has been issued.
Now, Millard, in
Give
this,
me a second, Mr. Chatterjee.
Yes.
Yes.
Now, my lord, if I take this notification to be compliance by the KMDA because they were in possession, if I take it to be correct, they are in possession, my lord. They had to send replies to the department that whether we require or not. My lord, if they do not send any reply, my lord, to the department, my lord, the department suo moto says, my lord, anything, whatever happens in 3-1, whether happened or not, my lord, lands will go out of this requisition process.
But it will not apply in a case where 4 has been complied.
Now, my lord, to this, my lord, when I seek this page 31, may I come to now, my lord. In 2001, the department clarifies with respect to 3 darks that these 3 darks, my lord, is not been used by anybody. This is lying idle because I say, my lord, in 2003, now, my lord, I relate to my previous argument of Haldiram. In 2003, my lord, the KMDA, my lord, now signs an agreement with Haldiram for doing what I don't know. They sign an agreement. Haldiram comes into a private limited company, comes into a picture. So, my lord, land, the purpose, my lord, in 4 is, my lord, for transport communication for creation of bypass. For creation of bypass. This is the public purpose for which 4 was issued in 74. In 99, they write letter, we are under process of this acquisition, and now, my lord, relates 97. That's why KMDA writes, my lord, we will bring it under the process of acquisition. So, my lord, Act 2 has lapsed. Now, my lord, they say now under Act 1, they will do it.
Section 4 is complied with, vesting complete.
Section 4 cannot stand alone, my lord, without compliance of Section 3.
That I have understood, sir.
So, my lord, if today, my lord, I keep my argument as on date, my lord, Section 3 has not been complied. My lord, if they say, my lord, this document may...
Yeah. Your saying will not suffice the purpose.
Absolutely, my saying will not suffice. Let them show.
You have to show that Section 3 compliance was not there.
My lord, how can I show? It's an order of the land acquisition department. My lord, it's not my order that I will show. Today, I am showing before my lord information which says these are beyond scopes of land acquisition proceedings. Even if I do not take note of page 31, the information under, my lord, the RTI Act, they say it is beyond the scope. So, today, if they want to revert, I understand.
Page number 31 says cancellation of
cancellation. I have whatever document I have got.
Documents have come that 4 has been complied with. So, vesting complete.
No, my lord, no, vesting under Act 2 doesn't. My lord has accepted the condition, and I also bowed down under Act 2, my lord. 4 notification without presupposing 3-1 doesn't happen. So, my lord, if that be so, my lord, if I fall back on page 30 of the writ petition.
30?
30.
What is that?
My lord, the answer in the RTI or the information slip to my question from the land department, 30, 29, my lord, whichever my lord takes, says that they are not been affected by any LA proceeding.
Documents are placed before this court that there was an acquisition.
Creation of a document, publication, my lord, LA proceeding.
The government will create document.
I don't know. My lord, if my lord, this is something, my lord, they have to prove, and I will rely upon judgment.
Very good, sir.
I will rely upon decisions.
I understand. What have you got to say with regard to page number 59 then?
59. Yes. 59, my lord, is the document where, my lord, today the land for which it was under 4 notification was made, my lord, is for public purpose. They say if you do not use the land, keeps it lying as usual. So KMDA was supposed to use the land for that purpose.
Yeah.
Till date, it has not been used. My writ petition comes in 2008, so they cannot say I've created an encumbrance in 1997.
They have to return it
They have
with
to
the
return it.
entire and for the utilization, they have to pay you the compensation.
Yes.
That is your case, I believe.
Yes, they have to pay compensation to the department, because department would pay me the compensation for unauthorizedly holding the land by KMDA. Now, my lord, if that be so, my lord, today KMDA, my lord, has to answer, my lord, they have not used the land. They are only relying upon a possession document, nothing more, nothing less. That
No, Section 4 document is there, sir.
no, state has produced Section 4, but
Be that-
KMDA
is a functionary of the state.
KMDA has to pay. My lord, I will show documents filed by KMDA also, my lord, in their opposition. KMDA in their, my lord, opposition has said, my lord, take it when they are entering into, my lord, agreements with governors, my lord, in 2000. My lord, they say that the process of acquisition is on. Kindly remembers, my lord, they're entering agreement with governor, not anybody. So on that day, they are saying that the process of acquisition is on. Now who to believe?
Very good. Then, any
Now, my
more
lord,
submission?
kindly takes up, my lord, my opposition. My lord, this is interesting, my lord. Kindly takes up my opposition to the state.
Your opposition reply.
Sorry, my lord, my reply to the state.
এই রিপ্লাইটা দাও গো, এটা তো রিপ্লাইটা কেএমডি এর রিপ্লাইটা দিলেন, কেএমডি এর ব্যাপারে। ওটা কি নিয়ে গেলে? এই নিয়ে গেলে কি ওটা? ও রাখো, কিছু নিয়ে যেতে হবে না।
Now, my lord, in opposition, my lord.
Give me a second, sir. Yes.
Now, my lord, kindly turns to page 14. My lord, this is an order passed under, my lord, section 44(2)(a) of the Estate Acquisition Act. My lord has got this order, page 14.
Certified copy of the judgment in proceeding under
44(2)(a) of the West Bengal Estate Acquisition Act of case number 1 of 2005. Now, my lord, what happened, why this proceeding was initiated? My lord, kindly recalls there are certain intervening applications. My lord, those interveners are respectfully coming to this court saying that there is no acquisition. We are the owners of the land. This land belongs to Rani Rashmuni. So we are heirs of Rani Rashmuni, and these records are to be corrected. So they approach, my lord, under this act, my lord, for correction of record of rights. Now, my lord, 44(2)(a), my lord, if my lord reads in, my lord, this has some finality in nature. Unless challenge, my lord, challenge period, there is a period of challenge. So, my lord, if nobody challenges, this has a final bearing on everybody under the sun. So, my lord, in this proceeding, my lord, the relevant part, my lord, kindly turns to the next page, page 15. Notices, my lord, has got 15, my lord.
Yes.
My lord, kindly says order number 374/2003. Notices duly issued to the Atindranath Das, deceased legal heirs Shamoli Das, wife of Ajay Kumar Nath, and Omlan Das, son of Sri Ajay Nath Das, both of 119 Rajbari Avenue, PS Lake, Kolkata 29, and to Ramlal Mondol, deceased legal heirs Shambhunath Mondol, Profullo Kumari. My lord, this is where the petitioner comes in. Mondol, Madan Mondol, and son of such and such. Now, my lord,
it is Profullo Kumar.
Profullo Kumari, my lord, these are the fraudulent records. The starting is the fraudulent.
This is something, my lord,
Everything is
Kumar,
fraudulent.
not Kumari.
Profullo Kumari. And she died in 1950.
relevant jagata aschi. Now, they will shout as many times they can. My lord, I am not opposing their shouting.
So how it is relevant, sir?
Why I tell your lordship, now kindly turns.
I am to come to a finding whether the acquisition, after acquisition has been completed.
I will relate this.
That I am to,
kindly takes page 24 of this proceeding.
Page 24.
Yes. Running page. No, running page. 24 here. Running page.
Yes.
My lord will find in the Mouja Kosba, what is the finding? District such and such, the numbered second DO. This Khotian numbers 1152, this correspondence to this Dags, and my lord will find name of the Rayat, Profullo Kumari Dotto.
Do 1152 834 689.
These are Khotian numbers, RS Khotian's numbers.
Khotian number.
Now, the corresponding RS Dag numbers are those Dags which are in dispute.
Yes. Profullo Kumar?
Profullo Kumari Dotto.
Kumari, where from will get it? Kumari is
Kumari is written as KR.
It is Kumari, my lord.
That can be said.
Very well, my lord, kindly do not say, my lord, I am the, because I am not in title, that I will see, look into civil court. My lord, this recording of this plots in name of Profullo K.R. Dotto, if I may put it in that. This order has been passed by under 44(2)(a).
Does it create any title?
My lord?
Does it create any title?
This records, my lord, this at least prima facie shows, my lord, I have interest over the land. Title, my lord, civil court will decide. I am not in writ court for deciding title. I am saying the authority, the land revenue department, while under proceeding under 44(2)(a), doesn't find the land to be acquired, but finds, my lord, the some Profullo.
No, those are based on possession.
No, not possession, because later part of the order I will show, on the basis of the records, my lord, certain corrections have been done under this proceeding.
Sir, estate acquisition has an overriding effect of the Act 2 of 1948.
No, I'm not
Then-
on that. My lord, kindly do not take my submission as an overriding effect of anybody. My lord, I am trying to submit, my lord, today, my lord, they say, my lord, the land has been acquired. My lord, if the land stood acquired,
I understand your condition, submission that you want, your main submission goes to say that your land was not acquired in view of the non-public non-compliance of section 3 of the Act 2 of 1948, and your second fold of submission is that section 4 cannot stand alone unless section 3 has been complied.
Yes.
And you have got the correspondences from those authorities clearly stating that in respect of 3 plot numbers, there is no LA cases. These
No
are
LA
these are your cases.
yes, my lord, to support and corroborate that, I bring in this 44(2)(a) proceeding order also.
It is not required.
Now, my lord, if my lord, I am showing, my lord may consider, may not consider. Now, my lord, kindly takes up page 32 of
32
the
of
same
what?
opposition,
Reply.
of the same reply. My lord, got that, my lord?
Deed of license.
Yes, my lord, between
CMDA.
CMDA and Messrs. Holdiram Private Limited in the year 22nd of May 2003. Kindly turns over the relevant paragraph, my lord, at page 33. My lord, whereas I will read, my lord. Whereas the license has been supplied to the authority for lease of the plot of land in East Calcutta area development project mentioned and described in the schedule hereunder written, which is in the process of requisition by the state of West Bengal for the purpose of the authority under due process of law. This is in 2003.
Sir, admission does not create any title.
I am not for a moment.
Does not give a go by to a title.
My lord, I am saying, my lord, if all authorities.
By this document, you cannot convince that by this declaration, they have disowned their title.
May I just put this question to myself?
Sir, if I say Eden Garden does not belong to me, does it mean that it was previously belonged to me?
No, not at all. If it
belongs to me.
If it belongs to me, I have to show document it belongs to me.
Absolutely.
Let them show where they have.
That is the main point.
So, my lord, I am.
That is true. That is the main point.
I am corroborating my submission, my lord, by showing, my lord, my.
So this is not corroboration. You may say that there are some contradictions.
That's why I make this submission
but
today.
Fact remains that they are paragraph 6. LA case number matches with page number 31 of your
31. Very well. My lord, 31 if it matches, my lord, and if they say.
The main question is, if the LA acquisition or proceeding was of 73 and 74, what are you doing till 2003? 2003.
2008.
No,
2008.
No, my lord, I was
How do you explain your delay and latches?
In 2001, my lord, I obtained documents from the authorities that it is eligible.
Sir, It is of the K of 73, 74. And you have
So,
said
Milord, there was nobody. Kindly sees my averment in the writ petition when it all for surfaced. What is happening? Milord,
the delay and laches creates a bar to get a relief.
no, Milord, in case of acquisition proceeding, if my lord shows, I will bring those decisions online which says, Milord, even if I come before this court 10 years down the line, and Milord, I show that my land has not been acquired or any land has not been acquired, Milord, acquisition doesn't makes it perfect. If it is not acquired, it is not acquired for 20 years to come.
That's true, that's true.
So, Milord, therefore, Milord, this delay would not hamper, Milord, an illegality which is going on. Milord, today I rely upon these documents to show, Milord, the authority who are supposed to have in control of these orders under Section 3(1) doesn't have. Now, Milord, kindly allow me to show certain documents. There is a civil litigation between the parties, Haldiram and KMDA. Milord, what has happened, Milord, now in civil litigation, they also say on oath I have stated falsely. Let them say they have stated on oath falsely before a civil court. They can defraud any private party, but in court they will also defraud. My question is to this. Kindly text my opposition, Milord. Milord, kindly text Milord page. Running page, Milord, 47. Milord, this is a judgment passed by a civil court. In written statement, what they have stated, kindly sees the KMDA. Court records the written statement of defendant. Defendant entered into the suit and contested the same by filing written statement denying each and every allegation averred in the plaint 7 Excel water matters of record. The defense case is that instant suit is not mentally as the same is barred by the principle of acquisition and estoppel. The defendant has virtually stated in paragraph of his written statement that the defendant authorities informed the plaintiff that the title of the property is yet to be cleared by the land acquisition department. This is on oath before a civil court. And this defense, Milord, comes in title suit of 2009. Haldiram has proceeded against them for playing fraud upon them. So, Milord, on oath before a court, they are saying, Milord, title is not perfect.
But Haldiram's suit was dismissed.
Yes, they are in appeal. Milord, what will happen to that suit? But this averment in oath remains. Milord, parties may come and go, evidence will remain. That's the settled position of law.
Very good.
Now, Milord, now, Milord, kindly takes up the opposition by KMDA, Milord, for once. This is filed by Abhishek Guho.
Yes.
Now, Milord, kindly takes up page 12 of the opposition. It is that document.
It's a KMDA.
KMDA.
Same notification.
No, this is with governor. They are entering into an agreement. Kindly see. This is an agreement with governor on 96.
Page number 11A.
No, Milord, 12.
Oh. But 11A is the same document.
Yes, 11 has that
That
notification.
document, oh. Page number 12.
12.
I'm sorry.
This indenture made this 22nd day of January 1996. My lord has got this. Between the governor, my lord, I'm not reading the rest part, my lord. Kindly takes up paragraph 2.
2.
I will refer few paragraphs, my lord. Whereas at the request of the authority, the land herein after describing the schedule and referred to the land where requisition and thereafter acquired by the provisions of such and such on behalf of the authority for public purpose of creation. My lord, kindly marks this. For creation of better living condition in rural and urban areas of the construction, reconstruction of dwelling places and for other purpose connected therewith and incidental thereto, as also for the establishment of commercial and industrial estate, which West Calcutta area development purpose indicated thereto. Well, kindly takes up the notification side by side for providing facilities for transport and communication, namely for construction of Eastern Metropolitan Bypass.
We're reading which portion, sir?
My lord, the paragraph 2, my lord, has read, my lord. Side by side, that section 4, my lord, kindly takes up, my lord, which they rely upon. Page 14 of the opposition by state, the gazette notification.
So it is also there, 11A. Previous page?
Yes, previous side by side, my lord. That
Oh, I see. Every in opposition of the state.
Now, my lord, the first paragraph, the purpose is recorded as for the public purpose for providing facilities for transport and communication, namely for the construction of Metropolitan Bypass. So, my lord, they say, my lord, if at all, my lord, I take this statement to be true, then this is not this notification which they rely upon. Because the purpose which has been defined in paragraph 2 is absolutely different. What is there in page 14?
It is in respect of same plots.
Yes, absolutely. Now, my lord, paragraph 3 is more important. Kindly takes paragraph 3 of that agreement between governor and the KMD. And whereas,
give me a second.
Yes.
একটু এই এখানে দেখুন তো ফ্ল্যাগ আছে, দেখুন তো ফ্ল্যাগ এইটা একটু দেখুন, এইখানে রয়েছে, এই তো সামনে রয়েছে, দেখুন। ইয়েস, বার করুন, খুলুন খুলুন একটা খুলুন, খুলে দিন। Yes, paragraph 3.
And whereas it was agreed inter alia that the authority should pay to the governor all compensations to be awarded and all cost, charges and expenses payable in respect of the said requisition and acquisition. And it was also agreed that the governor should, after acquisition, execute and do all acts and deeds necessary and proper for vesting of the said land to the subject to the terms and conditions herein provided. So, my lord, in 1996, they say after acquisition. So, my lord, for the new purpose, entering into with Haldiram, my lord, if I may put it in that way, my lord, the fresh acquisition was presupposedly, which is not the acquisition at all, my lord, was indicated here. So, my lord, they were very well aware.
No, this agreement is between whom?
Governor and KMDA.
Regarding?
Regarding the usage of the plot of land with Haldiram. Absolutely differ for a different purpose now. My lord, here I take another point. আসছি 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 আসছি, আসছি। আগে দেখাই কাগজগুলো না দেখালে তখন বুঝতে পারবো। Now, my lord, kindly takes up the schedule for once of this agreement. My lord, I will show that these three plots were involved into this. Page 15, paragraph 13. There is a reference to these three dogs. 3775, 3777 and 3778. It will take some time. Next Friday, my lord, I am not in Kolkata. Can it be done Thursday? Because I'm continuing, I can finish it. I am not be in Kolkata next Friday.